Please.
Yes.
My lord, I have, by way of this, I have flagged an issue which I believe requires your lordship's consideration one way or the other. Your lordships had issued notice, my lord, on 17th of September and thereafter, my lord, by a detailed order of 7th October, my lord, this constitution bench has been You know, the 7th October order, if your lordship just has a look at, mentions both sides of the argument, other sides' arguments as well as this side, and what I have submitted, my lord, before your lordship for your consideration. Can I just place that for a minute, just 1 minute? My lord, if your lordship has 7th October, para 2. This court, by the order dated 17 September 25, had considered an application filed by amicus who pointed out anomalous situation in most of the states. Judicial officers recruited as civil judges often do not reach the level of principal district judge, leave aside reaching the position of a high court judge. This has resulted.
Yeah, I think all of us have read the order.
Your lordship have read.
Yes.
So now, my lord, having read that now, so now there's a few interventions have been filed as per the office report 8. So 4 seem to take the view that what I'm saying requires consideration, and definitely 4 are opposing it. So my request to your lordships is if your lordships would have it on some day for hearing.
Yes, so we'll
yes.
fix up the date.
So, my lord, what
Total council. This, of course, my lord, the amicus has some information on this, but your lordship has noted that there is a different high courts have different experience.
Yes.
Correct, that's it.
Your lordships are under this have, my lord, constituted a committee, a fact-finding committee, for the purpose of seeing whether this problem is as
Fortunately, all 5 of us have experience of the.
No, that is true, my lord. But what is the current state of facts, my lord? Because there is evidence both ways.
My lord, so far as the current.
Lordship to consider whether there should be, it should be first referred to a committee, somebody your lordship may appoint.
So that data would be available to us. All the high courts are before us.
I am going to file. In fact, last time.
All the high courts are before us, so it's not a very difficult data. So they have to just give 2 figures, 3 figures, the total number of service judges appointed to the high court. Out of them, how many from the directly recruited from the bar, and out of them, how many promoted.
Your lordship may recall last time, my Lord and Justice Chandran were on the bench. I had handed over a compilation of whatever the High Court has said. I'll file it with my compilation before argument so that everyone can have a look at it. No problem.
All states have not filed affidavits.
Oh.
And we have not yet given the detail. Your lordship believes.
We are applying for Calcutta High Court. Calcutta High Court.
Here for Delhi High Court, my lord, the position is reversed. Out of 13 principal district judges, only 2 are direct, 11 are promoted.
Therefore,
and my lord, in the High Court, my lord, there are 17 honorable judges.
So therefore, if they view
I prepared, my lord, lordship, I formulate some question of law.
that will
vary from state to state.
No, that's what I
Some all judges are from civil judge.
That's
They
what-
are no more administrators.
No, so lordship, I formulate some point which I have suggested, my lord, subject to your lordship's
What are the points?
Kindly give it.
There's also data of all the high courts are not available.
Wherever the recruitment has taken place annually in terms of the timeline laid down by the school, probably there the direct recruits have got a lot of advantage. But where the
Selection has not taken place yet.
take place for a couple of years, obviously only the.
But normally, the Malik Mazar matter, your lordships have been supervising that, monitoring it also. So therefore, my lord, by and large, it has been complied. Malik Mazar.
Just take a copy if you can.
No, who says it has been complied? It has not been complied in my state.
But by and large, it has.
I don't know. There's nothing, no record to indicate.
No, this is this.
Can I,
So,
my lord, can I make a
One
submission?
minute.
Yeah, just one submission, my lord.
let
Yeah, your lordship finds,
the amicus,
we may have to consider whether, no, yeah.
you want the amicus, what
No,
question you
but
want?
I thought before we start, I thought I'll make one submission in all humility.
We are not starting today.
No, not argument, my lord. My point is, will a five-judge bench be sufficient is a question that I want to humbly bring to your lordship's notice. Two constitution benches have taken the clear view when an integrated cadre is constituted by two sources, thereafter discrimination is impermissible. Two constitution benches have taken that view, and therefore your lordship may have to consider whether we can, the five-judge bench at the end of the exercise, we should not be stuck with that, my lord. And I thought it my duty to point out before your lordships, please consider whether we can do that at the end of it, after taking a lot of time. This should not trouble your lordship. I'll cite those two decisions, your lordship may kindly see them. They are authority for the proposition that when two streams make a common integrated, their birthmark loses. Thereafter, there's no birthmark. You cannot thereafter make any reservation. That would be offending Article 14. And therefore, that question, if your lordship want to alter that, maybe your lordship may consider. I'm just pointing out, my lord, your lordship, because at the end of the day, I don't want the whole exercise to be a wasteful exercise.
What is our interpretation? We don't apply because we are saying that experience is something that takes it to a level of. Aware of those judgments, and I'll be citing them first when we start the matter, because I don't think they cover the point at all. In fact, they are open to interpretation. I know the two, Roshan Lal and Milord Triloki Nath are the two judgments.
These are the two judgments.
Correct.
I'm already aware of that, so I'll be dealing with that, but your lordship will hear it holistically with everything else. That's what my submission is.
No, but all that I wanted to submit was, Lord, all.
Exceptions to it where you can deviate without reaching Article 14. This judgments are not there as a constitutional dictum where they will apply invariably in every case.
That's right. So that's my submission. I'll be
I think they are. That's a point to be. At the end of the day, my lord, at the end of the day, let it not be seen that, will it be better to have, you are investing judicial time in it. So let's be sure that we can do that. That's all that I say. So,
by 27, we will consider this issue also whether it requires we refer to a larger bench or not.
What are the questions according to you are arising? You just formulate your respective question.
Your written submission, on the top you frame your question and then you can give your submission.
We'll do that.
I think
All of-
formulate the question.
us
it's
can-
easier
all of
for
us
us to
can-
address your lordship.
You know what is the issue?
I pay for the haiku.
No, we have identified the issue in the order.
The orders, the issues identified, the prayers are actually the prayers in the IA is the issue.
The prayer in the eye also is identifiable. It's not something vague. Like,
My lord, there are some more
My lords,
intervention
my
applications.
lords, I appear.
My lord, there are some more
We have
intervention
moved an
applications.
intervention
No, lordship,
application
allow the
last
intervention.
evening.
Last time you
Lordship,
not
I can't allow the
You can hear all of you, but
Lordship would formally allow.
what was it to allow and
But the register is easier for us to file commissions with them.
Last time, my lord said all interventions allowed.
So-
Last time that is
There are
there.
few more.
There are four, five applications.
all interventions which are filed till today are allowed.
Yes.
Lordship, please.
Request, no, there's one.
Otherwise, they'll be floodgate.
Lordship till today.
Because that is one IA, because I have filed.
So that is what we have said. Other way of saying it.
I got one at 11 PM last night.
Because one, yes, because we had filed one intervention application on behalf of this income.
Whatever are filed till today will be.
Lordship, please.
So lords,
My intervention was filed.
from our side, Manu Krishnan can be the nodal
Yes,
counsel.
Mr. Manu Krishnan.
Yes, from our side, he's, Mr. Basant is also being instructed. Manu Krishnan is,
And
Mr.
from
Bhatman.
your side?
My lord, I was thinking I'll give my submissions along with.
No. There should be a nodal council who supports your.
That's what I'm, no, what I'm saying is, so the amicus will give it, I will give it, and then one of the other, perhaps, Miss Mayuri Raghu.
Miss Mayuri Raghu.
Yeah, she can do that.
But there was one factor which I wish to point out, subject to, may have been disclosed to Lordship's already. Because in our case, with delay stated Bihar, that then the judgment of Lord Justice Chandra perhaps will then be under review. But Lord Justice Chandra's judgment may be under review.
Vinod.
It may be under review
Which judgment?
from the Bihar High Court, what it has come. And it's in appeal not before Lord Justice Srikant also.
So that's not, I don't think that's an issue in that.
That was only with respect to who gets seniority, correct? Who gets it, the direct recruit, the Bihar rules provided that the direct recruits will get seniority. That's about 94 people at one go. 2011 to 18, there were no selection. So that is a peculiar situation. That I said that.
That itself would be subject matter of debate before Lordship. Not be intent to raise it because rule says not the direct recruits are going to get their seniority from the date prior anterior to their appointment. It is not permissible.
We will not be able to determine the interest in seniority of different states.
Wish to do anything else except to point out that.
That is an unending process. We can only lay down the general principles that will have to be followed.
I don't think your lordship will go into individual high court rules, otherwise then your lordships never. Individual high court rules, I don't think your lordships will be going into in this matter at least.
Like what we have done in Giraj Home, we will be laying down the principles.
Right.
Which will be followed by all the high court and the state government.
Please.
Just for one piece of clarity, after going through both orders, there seems to be one aspect which is of the principal district judges and the recruitment to that. The other is with reference to high court judges and where they come in. Would the questions be framed on both? Or is it with reference to cadre of principal
As my
district
Learned
judges?
brother has pointed out,
Yes,
as far as high court is concerned, it's not a promotion.
yes.
It's not a.
No,
It's not.
No, your lordship.
No, so referring to the problem is in Kerala, for example, they don't have a cadre of principal district judges. There's no cadre, it's not in the rules, what they do. Yes.
Gopal, in
Yes.
most of the states, there is no designation nomenclature
Correct,
of principal district judge.
Correct.
There is only a district judge. Right?
Yes.
So wherever in the state there is a principal district judge or in the other state is a district judge,
Yes.
I think that's one and the same thing. It's only question of head of the district judiciary.
Yeah, exactly.
Let us take in general parlance as head of the district judiciary.
Yes.
So what should be the mode of,
Sourcing.
interest determination of seniority in that cadre? That can broadly, as Honorable CBI has pointed out, we can lay down the general guidelines and principles, which can then could be followed by states, respective states in the consultation.
If the amicus could
It's a
frame
question
those
of- it's a
questions.
question of nomenclature.
Yes.
Wherever there is a principal district judge, the head of the district is called principal district judge.
Sorry.
All others are called as district judge.
Yes.
Wherever the district judge heads the district judiciary, others are called as additional district judge.
Actually,
The reason
actually, the better expression that all of you can use is the inter-se seniority in the superior judicial service.
That's correct.
Basically, because it's a question of determination on the entry point.
That's
And entry point is in superior judicial service.
Not
Some of the
superior,
cases you
superior
might
stroke higher judicial service.
Before even higher judicial service in general.
But yes,
But within the higher judicial service, one is a.
how can it be Mr. Ansaria that probably you
Posting, my lord, as a-
It's not a posting.
It's a posting, my lord.
It's only a post.
No, it's the administrative side. It's the administrative side of the High Court. It's the administrative side of the High Court, my lord. They decide who may not junior.
and they look at suitability, so they're not looking
Are
at.
they same? And
Courts are fixed. Some posts, Mr. Hansaria, you are right. It is a complete cadre of district judges. But some posts in that cadre are fixed for district judges selection grade. So there are stratification in the cadre of district judge itself. There is the first district judge entry level, then you have the district judge selection grade,
And then super.
and then you have the super time scale. So what happens is, for the post of principal district judge, a district judge entry level is never considered.
Yeah.
You must
My lord,
you must be upgraded
Yeah.
to a district judge selection grade. Then only you come in the zone of consideration.
my lord, so for
So
example,
what we
yes,
propose to consider is
yes.
that this zone of consideration of movement again is not on seniority per se.
Yes.
It is merit cum seniority.
Yes, my lord, that's what
So
I want.
let us say if the selection grade comes into 5 posts,
Yes.
we have to have a zone of selection of 15. Would we put in a preferential quota
Yes.
for the promotees from the base level, that is the civil judge junior division level, for consideration and the zone?
My lord.
This is an issue which we would like to discuss.
Yes, Lord, what I was submitting is, my lord,
It is.
that
it is-
within
it is hard
the
to
rules,
understand
my lord,
issue.
so far as Delhi is
And that
considered
is why we
administrative
need to
orders.
assist
So
with-
would your lordship ask all the high courts and amicus to see, my lord, what are the provisions in all the high court? Because different high courts have different provisions. There are no rules, my lord. For example, there are no rules. There is a full court decision.
Mr. Ansaria, it's only because of lack of uniformity in the rules
Yes.
that this problem we are facing.
Yes, yes, my lord.
The very fact that all of you are and all of us are assembled here is only because of
So
this reason.
this will require collating all the information from all the high courts regarding the present stand and the provision regarding the rules.
Actually, Narendra, amicus is already having the.
It's, my lord, what has been given to us, it does not have.
No,
For
no. To
three
be
or four
fair,
high courts, it has
to be
only.
fair, I think the learned amicus is trying his best based
Yes,
on the
ma'am.
pleadings
It is
that are
not available.
Sorry, bro, I
That
can't.
compilation of all the rules
Right.
of the High Court, it's not 100.
No, we'll file.
25.
I'll file it with my submission.
Compilation of those rules, collation and a comparative table that in the case of seniority, how they deal with.
Yeah, I'll do
And then you can just prepare a small note of highlighting
summary of
the
that.
significant differentiation between that criteria.
Absolutely.
Sometimes they follow continuous length, the others follow the date of entry, the third follow roster points.
Right.
Sometimes there is a mix of rota and quota. So
Yeah.
these all,
Different. my lord.
there are a lot of
I'll make sure it's there. I'll file it.
Some of the high courts have placed the statistics with reference to the over the last 5 years from which sources they have come, etc. Some of them have not. Now I'm with Mr. Bhatnagar on this. He needs as much assistance as he requires to come up with this. In his own note, there are many states where the response hasn't come. So one suggestion that I have is if the registry of this court can reach out, then immediately it will come, it will be uploaded, and we'll have the advantage of that.
Because only 3 states have been given, my lord, perhaps in the note by the amicus. 3 or 4 states, because rest are not available. So Lordship may kindly require, my lord, consider issuing directions to the High Court. They must give data for last 5 years at the posting of principal district judges, and also, my lord, the relevant rules or the administrative guidelines for selection of or posting as a principal district judge. Because in Delhi, there is only a full court rule.
Let's not interfere too much of the, that's a domain of the High Court, that what should be the criteria of posting.
No, my lord, I want Lordship may have it. No, I am only saying Lordship may have that material.
Let's not unnecessarily expect the scope of this issue.
No, my lord.
That's absolute prerogative of the High Courts, we must respect that.
No,
What is the criteria of posting of the district, that has to be resolved by them.
No,
not by
but that is
Supreme
what your
Court.
Lordships are considering, my lord. What your Lordships are considering is
Let's not
what-
go left and right, straight to
No.
the issue.
the rules must be available to the court, my lord. That's all I am saying.
That's my learned brother has already informed. You didn't listen to what the his lordship was telling the amicus.
Which file?
He has already told him that you have filed a compilation of the rules.
That's all, my lord.
Yes.
And attempted to
also.
No, that's all.
do what falls from the court.
Yes, I've seen that.
They've already filed their rules, Lord, I guide them.
Not all.
Very good.
But usually this process is not governed by rules.
That's what we can't share you publicly.
No,
You know.
As far as this
Guidelines
Yes.
are there.
guidelines are there. my lord.
There are no statutory rules, there are guidelines or
By the full court.
Guidelines by the full.
The
Quite a fluidity about the issues involved in this matter. It's quite wide scale. Let the amicus perhaps pinpoint the issues and then we can proceed.
Yes, lordship may fix once again, once the amicus picks up the,
Coming so problem. Let the amicus frame the issues and we'll follow that.
very good. We frame the following question for consideration by the constitution bench. Correct. What should be the criteria for determining seniority in the cadre of higher services? From the well,
Issuance of lesser.
needless to say that while considering the aforesaid issue, we would also consider the other ancillary or related issues. The parties were, if the council were supporting the prayer made in the IA, would be heard on 28th of October, and the parties who are opposing the prayer would be heard on 29th of October. The councils shall file their submissions on or prior to 27th of October
27th.
2025. The nodal council for the parties supporting the prayer in the IA would be Ms. Mayuri Raghuvanshi, and the nodal council for those opposing the prayer in the IA would be Manu Krishnan.
Yeah.
File it by 27th.
27, reopening day.
28th.
28th, 27th will be reopening, my lord.
So 28th, 29th years.
Yes,
Right.
but
On the opening day, we don't want to pay for
I thought lordship was saying 27.
No, 27th for
it.
filing the statement, 27th, your lordship is saying?
Yes,
Yes.
That the reopening day, can it be, that's the reopening day, can it
Yes.
be a
so
little
you
later?
can file it on the opening day.
Lordships have allowed the IAs. for
Yeah,
intervention.
allowed the IS file till today. So you distribute the times.
Yes, so
Time slots amongst.
we'll make sure that our side is this thing, Mayuri.
That's what he said now.
Huh?
Arbitration's petition dismissed.
With your lordships,
Next date shown in 801 is 20th of October. Praying for it
not to be deleted.
grateful.
With your lordship's permission, may I mention item number 5 on the last occasion, it was to be listed on a.
Listed mention.
Sorry.
Please, Your Lordship. Your Lordship, this is for the petition for the bail application mentioning for urgent listing. Tentatively, it was showing for the 15th of October. Tentatively, it was showing for the 15th.
This will be posted in this week.
Lords 803 next date is showing as 17th October. Lords, it's a contempt matter. My lord,
Not to be deleted.
not great.
My lord, 804 is my lord, some IAs coming today, my lord. It's connected with those IAs only, my lord.
Huh?
Some IAs are listed, my lord, today. So these are connected to that only, my lord.
No. Now at the last moment, how can we should at least mention it yesterday?
My lord, what has happened, my lord? Friday list came, my lord. One IA is coming, which deals with my properties.
Not at least.
My lord.
My lord's 805 date was showing as 28, but my lord has fixed the constitution bench. May I request for 3rd November if possible? 3rd November. Grateful, my lords.
So much for your, as and when
Lordship, may I just.
We are not permitted to mention full lordship. You are not aware?
Your Lordship, I wasn't mentioning for any indulgence.
You don't permit mentioning in by any senior counsel.
Your Lordship, I bow down then, no issue.
May I be allowed to mention, my lord, item.
Lordship, this is already shown in the list of 28. I'm just praying it,
It's not to be related.
grateful.
Millards 808. Millards, these are the applications for recalling and grant of bail. The date is showing 28th October. So, let me. Yes.
May I please, my lordship, I'm a patent holder for a very acute drug. I have patent in 60 countries. This is a drug for a spine disease. It's a very rare disease. I've been holding patent for in 60 countries, and there has been an infringement of this patent. And I have enjoyed the stay before the single judge and before the High Court. The High Court judgment was pronounced on 9th. I'm requesting for an urgent listing because there'll be a problem if the other drug is launched, because this is a very, very serious issue. This drug deals with children and with the spine disease. So I'm requesting for an urgent listing. That's all, Lordship. With right of the
When is the order passed by the High Court?
9th October. Lordship, I filed it immediately. I filed it on Monday, 9th October.
With
Lordship, Friday, if it's possible.
Maybe this week, Thursday, Friday.
With your lordship, subject to your lordship pleasure. My lord, this concerns personal liberty of a senior woman journalist who was forced to go police custody after 7 months of securing bail, my lords. The bail is in operation, no cancellation of bail by the state. My lords, the PC against PC revision was filed by the state, my lords. After 7 months, I'm forced to go police custody now, my lords. My lords, my entire office has been seized yesterday evening. The orders.
Tomorrow day after tomorrow.
Tomorrow, my
With your lordships, my lord, may I mention a matter listed today, item 20?
Yes.
My lord, with permission, my lord is already allow my mentioning, my lord, and matter listed in last week, my lord, the 8th October, my lord. Unfortunately, matter is not listed. This is a very important matter, OBC reservation. Act provided 27% reservation. Contrary to the state issuing the notification, I was challenged. The petition for this against that SLP is pending. My lord, it's already around. So, my lord, this week before vacation, my lord, the people are waiting for lost more than 6 years, my lord.
My lord, may I mention, my lord, I mentioned earlier, my lord, it was listed but could not be taken over. Now it is showing 28 October, my lord, it may not be deleted.
With your lordship's
I am dying for raw material, my lord.
May I mention matter listed today 23, it is effective 30, your lordships. That IDO matter, consumer matter, your lordships, may be taken up today, match. Twice I have prayed for not to be deleted. It may be taken up today, your lordship. Consumer appeal it is.
So tomorrow I think we have some Ian goes out. It is listed today.
Your lordships, I'm just requesting it may be taken up today. because your lordships have a special.
We have the time, we will take it up.
With my lord's permission, my lord, this is
My
my
lord,
your lordship's
My application will not be taken up by the special bench today.
No, not now.
with my lord's
My lord,
permission.
may I mention urgent bail matter for this? He is in custody.
With the lord,
My lord's permission.
No, it's for bail.
Yes, my lord.
with the lordship's
My lords, I'm
permission.
mentioning a matter which my lords had listed as item 101 for 4 weeks. My lords, it's SR Power's claim against GUVNL, which my lords recognized the urgency and listed it top of the board on 17 September. My lords, for various reasons, it could not be taken up for successive weeks despite it being 101. On 9th October, my lords passed an order directing it may be taken up post Diwali. My lords, I'm requesting if it may retain its position, if it may be listed on 29th, my lords.
29th, they are already fixed as CP now.
My lords, in any other fixed date, if my lords may deem fit.
4 तारीख को करेंगे. It's a final hearing or a?
My lords, final hearing 101, it was listed top of the board.
With the lordship's
Grateful,
permission,
ma'am.
may I make a request?
Yes.
Lord, I am mentioning a fresh civil appeal by MSC DCL, which is a government of Maharashtra company. Now, my lord, the impugned order, the APTEL has refused to extend the interim relief. The matter is pending before APTEL. By reason of that refusal, yesterday the Prapti portal writes us an email asking for a stay order, in the absence of which, my lord, right in the Diwali season, there will be huge power cuts and increase in the tariffs, my lord. And
Interim relief was operating since when?
it was earlier granted on 28/7/2025, and then subsequently it was not extended, my lord. And our IA is still pending, my lord. Because now yesterday the emails have been received from the Prapti portal threatening coercive action.
Your Lordship,
My lord.
Your Lordship, seeking permission to mention this matter. There's a small urgency in the matter. The execution petition is already been reserved for orders, and the matter has defects have been cured in the matter. We've already circulated an urgency letter. However, since it does not fall within the categories of the 15 categories listed, the urgency letter was rejected.
What is the urgency?
Your Lordship, the execution petition is pending, and if it's passed, we'll have to pay an amount of 3 crores plus interest of 9% per annum.
No, the execution petition is pending. What are you challenging?
This is an order, Your Lordship, regarding Lordship, where we are the company and the complainants are the home buyers who have filed a claim against the flats that have been our flats.
Let's may I have permission to mention these pharmacy matters was coming up tomorrow. I'm requesting it may be taken up tomorrow. These two matters.
My lord, a transfer petition filed by the retired teachers from Karnataka state to hear their writ petition pending before the Karnataka High Court with the SLP filed before the Honorable in which all notices will issued, and my lord, petitioners are all age of 18 years above. Any date may be fixed, my lord.
They will give the date. Yes,
Your Lordship, if I may mention a matter.
Yes, Mr. Lord.
Your Lordship, if I may mention a matter.
Constitution of the bench in Amrapal unit, the court is of Justice Sanjay Kapoor, Justice Satish Chandra Sarma, sitting with Mr. Sanjay Singh Millet. And this is the order. If Your Lordship will peruse the order, the number of IAs of the home buyers. It is a special bench, Millet.
This constituted and they have, I think, given a date after it.
There are a lot of IAs which are pending of the home buyers, and the matter have been adjourned because this.
The date has been given by the special bench.
On some 17th of November also, the matter was.
You mentioned before Justice Sanjay Kumar.
If I can, because the order says if not.
I can't fix up the board of the other judges.
The order says that Justice Sanjay Kumar's order, if the Lordship peruse this order, please.
We have seen that order. Pursuant to that order, I have already constituted a bench of Justice Sanjay Kumar and Justice Sharma.
But I am requesting instead of 17th of November.
I can't fix up the calendar of the other benches.
Could you please,
Your Lordship,
May I mention?
Your Lordship, if I may mention, Your Lordship, in contempt proceedings in the Honorable High Court of Allahabad, the High Court has ordered for personal appearance of the officers. So regarding that, we have come in specifically. If Your Lordship may allow any time in this meeting.
Your Lordship.
Grateful.
My lords were free to issue notice in a case.
So you are not aware of the president of the
I'm
war.
here, Lordship, I am mentioning.
You don't permit senior armed conflict to appear.
My friend,
No, but as the chairman of Bar Council, you must.
My lord, we've
Lordship,
filed-
senior counsel appear in this matter, Lordship. It's a life of 30 students, Lordship. The exams are going to be held on November, Lordship. Lordship issued the notice returnable with 2 weeks on 1/9/2025, Lordship. So most urgency, Lordship.
Sir, just
30 students, we have served everything, Lordship, to all the services complete, Lordship.
Absolutely.
My
Your
lord,
Lordship.
I deny the work extension of time on the Umeed portal. We're only requesting that this IA may also be listed with the other IA on the 28th of October.
Your Lordship, you may mention.
Your Lordship, may I mention? Your Lordship, Your Lordship, it's a matter related to petitioner institution for the recognition year 22-23. And Your Lordship, High Court has adjourned the matter because there is a SLP pending in this honorable court arising out of a PIL. And Your Lordship, the SLP is related to academic year 23-24, and there is nothing related to 22-23. Your Lordship.
Then this you could have pointed out to the notice of the High Court.
Your Lordship, it was pointed out to the High Court. Your Lordship, it was filed before the Dussehra break and it hasn't been listed till this date.
So what do you want us to do now?
Your Lordship, it may be listed.
You are saying that SLP is pertaining to 23-24 academic year.
Yes, Your Lordship, but in our case, we are recognition for 22-23. We are not related to 23-24.
Your Lordship, these are the IAs in the Samaj Parivartan matter. Your Lordship had issued notice and are directed to list it after the Dussehra vacation. It was showing for 14, but it was not listed on 14. Your Lordship may list it immediately post Diwali. Your Lordship,
whenever the three judges bench is constituted.
Your Lordship may give a specific date because Your Lordship
Can't give a specific date. There has to be a three judges bench for that.
Your Lordship post Diwali week anytime convenient to you.
My Lord, 806, perhaps I missed when it was called out. The listed mentioning. It's an application by mining workers for certain benefits that were promised to us by the state in a counter affidavit filed before this court. I'm just asking for directions for that. Maybe listed on any date after Diwali.
It is also Samaj Parivartan, so it will have to go before three judges.
It's a tagged matter, my Lord, but not the same issue.
What is it? It is tagged by the bench.
My Lord, this actually wasn't tagged by the bench, but because it's a mining matter, I'm on a different point. They're on legality of mining. I'm for mining workers who lost their jobs after mining was stopped. I'm only on that when the funds were released. I was promised that certain housing and certain facilities were given to the mining workers. They have not been given.
We'll consider it along with that.
Well,
My Lord, mention a matter pertaining to the petitioner who was serving as a civil judge. His service was terminated. I'm only requesting for a listing this week.
When was service terminated?
Service was terminated, my lords, in 2020 by the MP High Court. Challenging the MP High Court judgment, I have come here. Effects have all been cured. I've circulated the mentioning letter earlier, only requesting for a listing on any fixed day.
Finally?
No, initially. The order was passed by the MP High Court last month, and then
Milord, may I mention PCI matter, Milord? The similar identical petition is listed tomorrow. May I request you to tag and list it tomorrow?
May I mention, Your Lordship, this is the mention of unlisted matter. So this is the anticipatory bail, and petitioner is suffering from chronic liver disease. So this is the urgency, Your Lordship.
My Lords, may I mention a pharmacy matter? In this, my Lord, the Pharmacy Council of India has rejected the application for B Pharma and D Pharma on 30th September. Similar matter, my Lords, are coming on tomorrow.
My Lord,
Gratefully.
may I mention urgent anticipatory bail matter for this?
Lord, the matter which is coming.
Before court number 5, I have filed 4 more SLPs on the same imprint order. Defects are all being cured, my Lords. Your Lordship can kindly tag the matter along with. Grateful.
Sir. Your Lordship, may kindly allow me to mention item number 5, my Lord. My Lord, by the order of the court, it was supposed to be listed on a non-miscellaneous day. Now, since this week has been declared as miscellaneous date, it somehow got listed today. If it could be adjourned to any date after vacations, my Lord.
Serial number 5.
Item number 5.
Okay. Which was the side?
My Lord, few of the advocates are present here.
You can mention it when it is called out.
My Lord, I'll do that.
Lord, I'm mentioning 2 SLPs for listing on this side of the vacation. In the first SLP, my Lord, it's an interim order where trial court permitted me to produce some documents.
Please speak in the mic.
I'm sorry, the trial court permitted me to produce additional documents, my lord. The High Court has set it aside. Now the arguments are going on. The judgment will be pronounced anytime, my lord. The SLP is numbered. I just want it listed on this side of the vacation, my lord. Otherwise, my SLP will become infructuous, my lord. The second one is, my lord, it's an award passed. Now the execution is going on, my lord. The SLP is registered. All I want it listed on this side because otherwise sale deed will be executed, my lord.
What is passed? What has happened in 34 and 37?
My lord, 34 I succeeded. 37 it was set aside. So therefore I am here, my lord.
Okay.
On this side of the vacation.
When is order passed in 37?
My lord, in one, it was the first one, it was passed on 17/9, but the certified copy came much later.
No, the order in 37 petition was passed.
8th of July, my lord, I filed it immediately.
8th of July?
My lord, I filed it.
Mentioning process.
My lord, I gave it for mention.
Some come through mentioning process.
My lord, the first one, my lord, may accept.
First note.
Lords, may I mention one fresh matter? Orders passed under 105B of the Mumbai Municipal Corporation Act asking me to vacate. My time to vacate is expiring on the 26th, my lords. The order was passed on 16th of September, but there were a large number of Marathi documents which required to be translated. The matter is registered. It's not verified as yet. Would your lordships consider taking it up on Thursday or Friday? Grateful.
May please. The fresh bail application minutes. I'm in custody since past 3 years, 5 months. Cross FIRs minutes, the complainant party and the accused party. Co-accused have been granted bail.
This trial is, what is the stage of the trial?
Trial means the 28 prosecution witnesses, 11 have been examined so far.
The trial will conclude in 3 months.
No, in 3.5 years, they have examined only 11 witnesses. It will take 3.5 more years. Kindly have the cross FIRs against each other and the co-accused. The High Court rejected my bail application has relied on a testimony of the co-accused of the complainant who is co-accused in my FIR against whom the allegation is of chopping of hand of the co-accused nursing.
We are not inclined to entertain the application at this stage, but we request the trial court conclude the trial as expeditiously as possible, and in any case within a period of 6 months from today. In the event the trial is not concluded within 6 months, the petitioner would be entitled to renew his request.
Great.
Please, my lords. Lords, the similar SLP is already dismissed on 6th, my lords. Now the same order may be passed, my lords. Lords, the order not to be treated as precedent the impugned order. Same order. Grateful.
Later.
Allahabad High Court has prescribed the criteria for establishment of Court of Civil Judge Junior Division and that of Magistrate. Lords, the filing, the pendency of litigation, in the district court.
Yes, but the court has found that there is no sufficient infrastructure and
that is for the government, my lords. Government land is acquired in 2018 and government is not making, my lords, funds available. As a result, infrastructure is not in place. Lords, unless the directions were given to the, my lords, government, and my lord, the whole purpose is, my lords, access to justice cannot be denied merely because government is not making infrastructure available. My lords, today, my lord,
civil cases are pending.
Lords, 20,000, my lords, criminal cases arising from, my lord, this tehsil. And today, my lords, under RTI, the data is not available with the district court administration. I pass on, my lord, the reply given to the RTI application. But so far, my lords, will be returnable early date. Problem.
So here the main point is like this. The Tenancy Act, my lord, puts a prohibition on transfer of land in Rajasthan from SC/ST to non-SC/ST. Now in Rajasthan, what they do is lands of SC/ST sold to housing companies. Housing companies take the land and then, my lord, change it to non-agriculture. The Tenancy Act, my lord, has a section called 90A. This deals with agricultural land being converted to non-agriculture. So then the housing companies convert that land after forming a cooperative system into non-agriculture. And large quantities of land, areas of land are being done. Now we protest, my lord, and we say that 19A of the Revenue Act has no relation to the Tenancy Act at all. Separate fields. The Revenue Act is agriculture, non-agriculture. The Tenancy Act is SC/ST land being taken by non-SC/ST. Now see the order. See first the section. Page B, my lord. 90A of the Land Revenue Act. Merely because a clause comes there, notwithstanding anything. Can you see that, my lord? Page B, I've extracted it. It said nothing to do with SC/ST Act. He says it overrides. Notwithstanding anything to the contrary contained in this Act. Middle of the page, my lord. Section 90A8.
Page B.
90A8. Page B, yes, my lord. Notwithstanding anything to the contrary contained in this Act. Any person holding any land for agricultural purposes in an urban area or within the urbanizable limits or peripheral belt of an urban has used or has allowed to be used such land or part thereof for non-agricultural purposes or has parted with possession of such land or part thereof for consideration by way of sale or agreement to sell or by executing power of attorney or will in any other manner for purported non-agricultural use, the rights and interests of such person in said land, etc., shall be liable to be terminated. Then go a few lines down. And thereupon the land shall vest in the state government free from all encumbrances and be deemed to have placed at the disposal of the local authority, shall be available for allotment and regularization for any permissible non-agricultural purpose in accordance. Now, my lord, this section, and see the next page, my lord, see 42B of the Tenancy Act. See B, sale, gift or bequest is by a member of the scheduled caste in favor of a person who is not a member of the scheduled caste or by a member of a scheduled tribe in favor of a person not member. Now, my lord, the court relies on the first part of the earlier act, notwithstanding anything to the contrary. That is, my lord, page B, top of that paragraph. Notwithstanding anything to the contrary contained in this act and the Rajasthan Tenancy Act. Yes, my lord? Now, my lord, kindly see the impugned order. Our argument is...
What is your grievance?
My grievance is, my lord, transfer of land from SC/ST persons to a housing cooperative is a transfer of land from a tribal to a non-tribal, and thereafter the regularization of that under the earlier section I read. You transfer it, you can't, because the housing society is of non-tribals, non-SC/ST persons. And then you regularize, and all these sales are taking place on power of attorney. So not having the document in your hand of title, once you go by the housing cooperation route, the government regularizes and gives you title under the section. Let me read that part, which I'm. And all the housing cooperations are setting up, housing cooperatives are being set up on tribal land in large areas. Paragraph 8, my lord. Section 90A8 of the Act of 56 begins with a non-obstante clause. Now, this is the main thing, my lord. It might be non-obstante clause, but the acts have nothing to do in common. One is agriculture to non-agriculture, and the second is SC/ST to non-SC/ST. There's nothing to do with the non-obstante clause. So he uses this to say that 42B, SC/ST to general, is now passed over, is sort of obviated by this. Provides that notwithstanding anything contained in the Act of 55, the provisions of section 90A8 of the Act of 1956 would apply. This is a non-obstante clause which has been made effective from so and so, 22. As the rider in section 98 of the Act is for agricultural land which is being used for non-agricultural purposes, and in cases where the khatedar has parted with possession of the land, section 19A8 of the Act cannot be said to be in any way contrary or restricting the rights available to members of the scheduled castes and scheduled tribes under section 42. Further, section 98 of the Act provides that whenever an order is passed by which the rights are terminated and before the property vests in the state, the officer authorized by the state government shall afford an opportunity of hearing to such persons. Therefore, section 98 of the Act of 56 affords an opportunity to all khatedars. Grateful.
This, my lords, we have to withdraw it, my lords, in terms of the order dated 6th October, my lords.
The same order.
Grateful.
My lords, the arbitral tribunal follows your lordship's judgment in Divan Chand and the division bench, my lords, in Gammon to hold, my lords, that the Workers' Cess Act would only be effective the date that it is implemented in a respective state. Now, admitted here contract is of 2007. These cess rules, my lords, are brought into force in Sikkim, my lords, in 2010. So therefore, they could not be applied retrospectively and would constitute a change in law within the meaning of clause 49. The section 34 court, my lords, affirms that. And my lords, the High Court in 37 reverses it without noticing, my lords, the fact that the Cess Act is not an omnibus act that applies in 1996, but basis your lordship's interpretation only comes into force in a respective state when, my lords, the rules are notified, the board is set up, and the assessment mechanism is created. And there is a letter which the state of Sikkim itself issues, which your lordships get at page 170, where they themselves say, my lords, that the cess has been implemented from 6/9/2010. My contract was in 2007, therefore my bid could not have loaded, my lords, the liability of this prospective, my lords, workers' cess.
Please, notes. Kindly have a look at page 102, notes. Their own contract specifically provides for this. Page 102. Labor and compliance with labor and industrial and other laws. 17.4. This is the contract which they enter into. During the continuance of the contract, the contractor 17.4 words at page 102. During the continuance of the contractor and the subcontractor shall abide at all times by all existing labor enactments, rules made thereunder, regulations, notifications, and bylaws of the state or central government or local authority. Now, let's kindly turn to page 105. Specifically, this act is there. 105, item 15. The Building and Other Construction Workers Act 1996 and Cess Act 1996, all establishments who carry out any building or construction work and employs 10% or more workers are covered under this act. All such establishments are required to pay cess at the rate not exceeding 2%, but not less than 1% of the cost of construction as may be notified by the government. The employer contractor to whom the act applies has to obtain a registration certificate and the registering officer appointed by the government. This is a 1996 act. In 1997 itself, annexure P1, page 68, 1% was imposed. Kindly have a look at note 68. This is a notification by Government of Sikkim, 26 September 1996. The issue raised was whether it's a change in law. The law existed in 1996. The imposition of 1% was there in 96. Therefore, the High Court says, how can you now put the liability on the company and not the contractor? And the directions of the arbitrator and section 34 are opposed to what the law is. And this law is prior to 2007 contract.
This identical clause was considered, my lords, in Gammon. There it was clause 34. And the High Court held, my lords, that would then constitute a subsequent legislation.
But if there is a specific contract between you and him,
yes,
which provides that the liability would be on the contractor or subcontractor. And if the cess is levied under the notification which is prior to contract.
No, it's not, my lords. Please see their own data.
At page 68.
No. 68 is the levy, my lords, of the
1%.
cess amount.
1%.
No doubt. But this act itself, my lord, this act is only made effective when the assessment mechanism and the board is established. That is your lordship's view in Divan Chand. Now, please see how the tribunal deals with it at page 291. 291, the view in Gannon, my lords, is referred. Please come to, my lords, 290 para 19.1. 19.1, my lords, the AT shall like to cite the following recent judgment in the matter of NHAI versus Progressive. Para 14 thereunder, my lords. In Devan Chand Builders, the Supreme Court had observed as under. Although both statutes were enacted in 1996, the central government, in exercise of its powers under Section 62 of the Act, notified the Building and Other Workers Rules 2002 via notification dated 10/1/2002. Accordingly, the government of NCT constituted the board via notification dated so and so. Thus, the cess act and the cess rules are operative in the whole of NCT with effect from January 2002. Now, this was then referred, my lords, in Gammon. In view of the aforesaid observations made by the Supreme Court, a division bench of this court in NHAI versus Gammon held that since the cess act became operative only when the BOCW rules were notified, the appropriate date for considering whether the cess act was a subsequent legislation would be the date on which rules were notified. Now, my lords, please see.
Where are the rules notified?
2010. 2010, my lords. This is with the additional documents. We have separate copies. 2010. And in Gammon's case, your lordships have issued notice in the SLP. These are the rules, my lords, of Sikkim of 2010, leading to their letter, my lords, P7 at page 170. Please see 170. That is the state's own understanding. Yes.
And then
102, yes, my lords.
17.4.
Yes, my lords, that is as may be notified.
No. Read it.
I quite see. 102.
It also considers the future also.
No, my lords. If my lord, that is 49, my lords. Any future levy is 49.
Please read 17.4.
Yes. Please. Salient features of the major labor laws that are
17.4 during continuance of the contract.
Yes, shall abide at all times by all existing labor enactments and rules made thereunder, regulations, notifications and bylaws of state or central or local authority and any other labor laws, regulations, etc. that may be passed or notification that may be issued under labor law in future either by the state or the central government or local authority. This is, my lords, adherence to labor legislation. What we are concerned here with is a cess and whether the cess impacts the pricing. So price adjustment is under clause 49.
No, but this is also labor, building and other construction workers welfare cess act.
No doubt, my lords, but that as may be notified, that is the language that is used there in 15, as may be notified. My lords, the question as to when the cess act came into force is not res integra. The question is, that has been decided by your lordships in Prabhakar Reddy and in Divan Chand, that it is only when the state-wise rules come into force that the cess becomes applicable. Now, this exact clause was considered, my lords, in
of concurrence. So,
yes,
unless you come within the parameters of
it does, because the
34 2B.
Well, let's kindly have a look at one more line, notes at page 102. In fact, my learned friend may not be correct. If page 102,
it's a reversal of award and 34.
I got on to that, but kindly
Your
have a look
lordship
at that.
is
It
held,
says
my lord, in
Divan Chand has been dealt with by the High Court at page
The scope is now very narrowed down.
I bought on notes.
We have recently considered it in
Varora, my lord, your lordship has held the change in law. What constitutes change in law?
That's not a different issue. That's the electricity law. But
Correct.
what about to change in law?
Correct, but everything that comes after the notification by an instrumentality of the state.
Even the scope under 37 is
Yes, that is a separate matter. Yes.
30. There's a recent judgment, I think, authored by Justice Justice Basi sitting with me.
My lords have taken the view here, lords, it's a patent illegality for the reason there is a law existing. It's only the implementation of the law which is existing. Divan Chand has been dealt with at page 24.
Right. My lord, item 33 I am appearing, my lord. It's along with this item.
Returnable. When can I reply?
In 4 weeks' time.
Let's stay in the meantime, my lord. Stay in the meantime. No.
Stay for
No.
Under the award.
All along, my lord, it was only by.
No, it has been deducted, my lords, by them.
They have an FD now, my lords, basis a settlement in
There's no
2016
question
because
of
the contract came to an end in 17.
That
That FD may be maintained by them, my lords.
You maintain the FD.
That's all.
We'll say status quo.
Please.
We have to FD.
Very well. Deeply obliged.
They should say,
They're different.
because not this amount was deducted while making payment to them over the years. There's nothing, my lords, at this
Nothing has to be paid now.
nothing has to be paid.
That may be recorded then, my lords, because these amounts are paid to the workmen, then we have to go after them to recover this amount.
Yes.
They have withheld it under a settlement. That settlement is in your lordship's.
But this is in 2010.
It's in your lordship's.
They are having your FDs. No?
Yes, they are, keep it as an FD.
Bio identity order.
They are not
Page 563.
FDs with whom?
They are not given any FT.
563, my lord, just see your lordships, they are to maintain an FD. It's a settlement entered into. In respect of this cess, the BOCW cess amount of 6.41 crore is withheld by SUL, that is the respondent, pursuant to clause, shall be in the form of a fixed deposit, provided that the FD shall.
You are only withheld it, so there's nothing.
They may release that amount, my lord.
Well, it's
Because
positive
the
mind,
case is that this is a workers' cess. Let that not be released.
So, the bio identity order, the response are directed to maintain status quo. Wait, the FDs.
Please.
Deeply obliged.
Deeply obliged to your lordships.
It's an arbitrator is appointed between the petitioner and respondent number one when there is no contract, my lords, between both of them.
You don't object to.
It was a wrong, my lords, consent given by the council. And my lords, contrary to law, my lords, kindly have an extra P1, that is the RFP. And P2 is the acceptance of tender, which is between the Ministry of Defence and Punjab's state supplies, civil supplies. My lords, Punjab in turn sublet this contract, whereas the conditions, the RFP clearly stipulated that there cannot be any sublet. Let's kindly have page 56 for a moment. This was behind our back, Malats. We never knew that they have sublet this contract. There are, Malats, clauses after clauses.
Your council gives the consent.
I agree, Malats, but it was against the legal proposition. Malats, I ask myself today, what will the arbitrator do? The contract between me and respondent number one is not there. He is absolutely a stranger to me. Let's kindly have page 56. In fact, we filed a review saying that it was wrongly.
You can against the council who gave the consent.
Now he's not there, my lords. We have not kept him in the case, my lords. But my lords, he...
Not in the case, but he continues as your CGSC.
No, my lords, that I need to take... well, it's instructions. I'm not aware whether he continues to be a CGSC. But my lords, he only, my lords, because he probably, my lords, he thought that the person who was there, and my lords, one important thing, what this person did was, the respondent number one, he made the Punsup also a party before the Honorable High Court. He's as a second respondent. He also did not object. He did not tell the court at that time that the Punjab Civil Supplies, with whom we had contracted. He was a respondent before the High Court. His counsel was present. He did not point out to the court that the contract is between we and Punso. Let's kindly have 56. For a moment, this subletting was not even allowed. Let's page 56, my lords. Clause 11, transfer and subletting. the seller has no right to give, bargain, sell, assign or sublet or otherwise dispose of the contract or any part thereof as well as to give or to let a third party take benefit or advantage of the present contract or any part thereof. So there was a specific condition for not doing so. Even after that, they entered. Kindly have, my lords, one.
Sorry, the learned ALG covered that. There was no contract between the petitioner and the respondent.
Number one.
Number one, submitted that the contract was between the petitioner and the respondent number two. It is further submitted that the respondent number two had given a subcontract to the respondent number one, contrary to the conditions stipulated in the agreement. Contrary to the conditions stipulated in the contract between the petitioner and the respondent number two. Issue notice. I have writing order. They shall be straight with issue order as well as the arbitration.
Deeply obliged, grateful for it. Delay might be condoned.
Lord, this may be taken up along with item 42 filed by the same petitioner.
So why don't you go to the High Court?
Lord, because of the reason. The first is that against me 58 FIRs have been filed for the one and the same cause of action in other writ petition. And this result of, I approached the Lokpal and Lokpal admitted, kindly see page 89.
But why don't you go to the Bombay High Court? This prayer can be granted by the Bombay High Court also.
Yes, but here I have come against the decision of Lokpal.
No, but and Lokpal, you can go to the High Court also.
In past, Your Lordship, in cases, Your Lordships have entertained the writ petitions in these types of cases.
Clearly, because we commit some mistake in some cases.
Very hardship. I am the member of parliament, independent, and I am being harassed like this because I raised my voice against corruption.
Is the law different for member of parliament and an ordinary citizen of the country?
No, but I am representative of people. I raise my voice against corruption.
So this voice you can raise before the High Court also.
58.
It will be heard expeditiously in Bombay.
Your Lordship may permit us to approach the High Court along with some protection be given against 58.
What protection?
For some time.
What protection we can give you?
No coercive action be taken because the case is not made out again.
Well, the learned counsel petition seeks liberty to withdraw the petition with liberty to approach the jurisdictional High Court. Dispose of has withdrawn with liberty as paid for. Both. Then what? Bombay is nearer to you. It's only even by road. It is.
In 42, 58 FIRs are there.
Yes, so you can go before the Bombay High Court. It is not as if it is not as if that the FIRs are registered in different parts of the state or different parts of the country. They are all registered within the jurisdiction of one district.
Yes.
The cases which we are normally entertaining is that if the FIRs are registered in 4 districts, 4 states, 5 states.
Yes, that is right, my lord. But some protection for some short time be given. So that otherwise I will be arrested for no cause. No.
You can go to Bombay tomorrow, file a petition. It will be listed day after tomorrow, and
no offense has been made out.
Thank you, Mr. Kalsi.
Nice.
Let's this is a transfer petition. I'm from the side of the.
Decide expeditiously because number will not. Its number will not.
Taken to consider the factors because the case in the event the petitioner approaches the High Court, we request the High Court to decide the prayer of the petitioner for interim protection expeditiously.
Well, this is a transfer petition. I'm from the side of the wife. We are seeking transfer of HMA petition from Family Court Gurugram to Family Court Kanpur, Milords.
Lord, there is a stay application as well, my lords.
Notice stay.
Briefly obliged.
Maybe led by Mr. Sushant.
Because I am aggrieved by dismissal of my section 11 because this is a very peculiar arbitration clause which on the plain reading would fall foul of Article 14 and lordships have said this in Perkins, DRF and very recently in Lombardy. May I draw your lordship's attention to the arbitration clause for a minute?
Yes.
On page 53 of the SLP, but also in the impugned judgment lordship may have it rather. Well, it's on page 24 PDF.
Page 24.
Yes, PDF page 24. Otherwise, was running page 3.
Yes.
Lordship has that. May I just read? If any dispute or difference arises between you and us regarding the amount of claim to be paid under this policy, liability having been admitted by us, such difference shall independently for all other questions be referred to a decision of a sole arbitrator to be appointed in writing by you and us, or if you and we cannot agree upon a single arbitrator within 30 days of either of us opting for arbitration, the same shall be referred to a panel of 3 arbitrators. So and so was then the procedure. Now the difficulty is the precondition in it is that the insurance company must admit its liability. And these are boilerplate contracts recommended by ADA. ADA is supposed to be protecting the interest of the insured against any arbitrary actions or inactions of the insurance companies. Here, it is rather giving a sole right to the insurance company to decide whether it wants to go in an arbitration or not.
There is an order passed by Justice Khanna also.
Yes, indeed, my colleagues are there with the copies of that. That also deals with it. That matter is still pending. And after Justice Khanna's order, ADA has now revised this policy and has come out with an amended clause where all disputes now can go before the arbitrator. But
directly to be tagged along with that matter so that they can be.
There was no difficulty. Lordship may frame a question whether these kind of clauses.
Khanna has already got an explanation from.
That explanation was given and subsequently ADA has amended its clause, but that applies prospectively. And that clause also, if I can just if Lordship has it, I'll just show if Lordship can see Annexure P8, page 334. Of the SLP. Just for a minute, that is the revised policy of ADA. Lordship has that, May I just read?
Yes.
We'll see the English part. On reference made by the Honorable Supreme Court, ADA undertook a comprehensive review of the extant arbitration clause prevalent across various lines. May see this is the background, and the clause that they frame, Lordship will see is 2. All policies issued under commercial lines of business shall have an arbitration clause as under. The parties to the contract may mutually agree and enter into a separate arbitration agreement to settle any and all disputes in relation to this policy. It's neither here nor there. While it says that everything can be covered.
We heard with SLP number 224-220 of 2020.
There's one thing, Malod. Just like yesterday, item 40 is becoming infructuous that the petitioner has been arrested, Malod. Interim protection, Malod.
But 39 is.
39 is he's there, Malod.
Same order.
40 is.
40 is over.
Under the Nursing Council Act passed by the central government, the eligibility is prescribed and they have the exclusive role. Eligibility, my lord, for classes of nurses, etc. You require, my lord, 10+2, etc. So the position under the Council Act was, preferably you can have a science stream in 9th, but my lord, in arts, history, etc. also, my lord, is allowed. Preference is given to science. There is no problem. Their colleges is going on, my lord, for last 40-50 years. Now, my lord, there is an MP local act. Local act is only, my lord, for registration. They have no jurisdiction to prescribe, my lord, like medical council, bar council. They have no jurisdiction.
Yes, it is.
So it was going on, no problem. Suddenly in 2024, my lord, the local act says that preference of science under the central act shall become solely, my lord, science. Your lordship will see that. That's completely illegal.
Where is that?
Yes. Your lordship will find, my lord, at 300 and starts at 302. These are called, my lord, MP Nursing Education Act, meant only for registration, nothing else. At 314, in the schedule, my lord, it starts at 313, the qualifications, and what they have done at 314, item 2, general nursing and midwifery, see, my lord, at the foot, one is 50%, etc., etc. Then, my lord, must have passed 12th with minimum 45% in physics, chemistry, and biology. So this has become now, my lord.
And where is the qualification provided by the central?
Yes, 78, my lord. The lordship go back to 78, my lord. At the foot, eligibility criteria for general nursing, etc. Age is so and so, minimum 10+2, passed, preferably science and English. So all streams were available.
No, where do we get 10+2? Eligibility for A&M or GNM?
Yes, yes. Both, my lord. Both. See, my lord, A, preferably science. B, you have arts, mathematics, everything. So if you have preferable science and you have equal marks, maybe, my lord, you will get a position.
Minimum.
My lord, see towards the end.
A3 minimum education qualification shall be 10+2 in arts, mathematics, physics, chemistry, biology, economics, political science.
Somebody is reading this. Yes. So, my lord, for A&M, the minimum educational qualification 10+2, arts, mathematics, physics, science. So, my lord, all kinds. For GNM towards the bottom, minimum education is 10+2, preferably science, and B, 10+2 arts. So all, my lord, vocationals are possible. So you have now, by an act where you don't have the power, you have cut the stream. You have blocked, my lord, people or children coming.
What is the learned appearing on behalf of the petitioner submitted that the qualifications prescribed under the rules by the state government is contrary to the qualifications provided by Indian Nursing Constitution. But he submitted. The same is not permissible in view of cutting off the judgment of this court right from with the citation of Adhiyanam.
Yes, bro.
So modern day, it is from Adhiyanam technical.
I'll give that link.
In an interim order.
What has happened is, this process is now complete under the impugned rule. I have lost out because there is a schedule. But there will be leftover seats for counselling. So what I am praying is, if any seats are left, they should be filled up by the unamended position. So I'll get some succor, my lord. I have been suffering for 1.5 years.
But I really wanted to direct that if any vacant seats are available, the same would be permitted to be filled in accordance with the qualifications prescribed by the Central Council.
That's okay. I'm very good.
May I please? Because on merits, apart from the fact that your lordships are seized of many petitions of this person, including the protection, the first part of the order which is under challenge, your lordships have repeatedly held the mere filing of charge sheet does not make my petition infructuous. There are orders of your lordships which say so. We bring the charge sheet on record, my lords. and High Court dismisses my petition as far as the quashing of the FIR is concerned. On that ground that now charge sheet is filed, we challenge the charge sheet. That is the first part, my lord. Now this charge sheet that I've on the Gangsters Act, which is there, sole case of a civil dispute between parties on which basis the FIR is registered, my lord. Kindly see that I'm not even named in that FIR in the predicate offence matter. I am named, my lords, in the charge sheet matter, my lords, once the charge sheet is filed, and therefore in Gangsters Act is invocation. All those matters of this person, my lords, your lordships have been seized with it and ordered protection to me, my lords, in the writ petition, etc., my lords.
Same order passed. To be tagged. Yes, same book, same order.
Wait for it.
Then the counsel from Gujarat would say that discriminatory treatment is meted out to him and as against the ones in Uttar Pradesh.
Uttar Pradesh, Gujarat is a better that way, my lords. Uttar Pradesh is still little difficult to, as far as law and order is concerned. Arey, theek hai, bhai.
Hopefully, he's not in court. Otherwise, he will request us to recall the order.
No, my learned
So Raju is here.
is insisting that the delay may be condoned delays of 40.
So that was not from Gujarat. That was from Damandiu.
But my lords, in all Gujarat people go to Daman.
Yes, for better reasons. On weekends.
That's why.
I have told similarly, Nadwar also. Nadwar, they go for worshipping Lord Krishna.
Yes.
And also for other priests.
Nadwar is in Rajasthan.
Rajasthan, but you are saying that all Gujaratis go to Damandiu. So they go to the Damandiu, they go to Mount Abu and Nadwar also for the.
All good Gujarati.
You are not required to go to any of
Oh,
such
I'm
places.
very comfortable.
He doesn't even go to UP with us. For good reason.
What?
Thank you.
Yeah. This is that TASMAC matter, Malad. I just want to point out something to your lordships, which is quite surprising. Just give it to my lord, the chart. Give it to the other side. Correct. Yes, correct. 2000. Exactly. Mullahs, just see this. There are total of 41 FIRs, of which 37 mullahs, 36 of them have been closed. Some of them, mullahs, closure report has been filed. And mullahs, what is TASMAC, mullahs? TASMAC is a corporation, mullahs. We are the ones who instigated the following of the FIRs, mullahs. All these. And we are a corporation.
You are the one?
Then we are the ones who directed the FIRs to be filed. Our officers, mullahs, are the ones that directed, mullahs. And this was all right from 2021. In 2021, we're a government company, mullahs. 100% government company, mullahs. They raid the office of the government company for what, mullahs? They say that there is a Prevention of Corruption Act issue, mullahs. That is quay individuals. If there's a Prevention of Corruption Act, mullahs, that's quay an individual. How can a government company, mullahs, be raided? And mullahs, what is it that we do, mullahs? The distilleries provide liquor to the regional offices, mullahs, and then the district offices. And mullahs, after that, mullahs, the allocation is done by the government. Everything is controlled by the government. There is no question, mullahs, of, and how do they, mullahs, take over the office, come to the office, raid the managing director who had nothing to do with these matters, mullahs. Raid the managing director. The then managing director who had nothing to do with this, mullahs. And as far as the 41 accused are concerned, mullahs, they have not been investigated, mullahs. What happens is the retail, the fellow who sells the liquor, mullahs, if he sells it beyond a certain price, mullahs, he commits an offence. And those are the ones that we are investigating. Now, mullahs, what they do is if an FIR is filed, this is the normal practice now, the ECR will be filed. Then they go into the state, mullahs, then they start, mullahs, investigating the matter themselves. So, mullahs, my request to your lordships is this matter, mullahs, can be closed in no time at all. For the simple reason, mullahs, that now it is for us to decide what to do, what not to do, mullahs. What is the ED doing there? They are mullahs, if your lordship sees their counter, they are investigating the matter, which they have no right to do.
seized all.
They have seized, Malas, all the phones of the employees, Malas. They have seized the computers, Malas. This is completely shocking. And I will, Malas, demonstrate. We can file our written submissions, Malas. 2 pages of written submissions, fix it up, Malas, and this.
My lord, it is, we have only searched the premises we are entitled to under section 17. Now, now there are 47 FIRs. We have found gross irregularity, large scale corruption in those FIRs.
But are they not investigating? Is the local police not investigating?
We are not investigating the predicate offense.
Yes.
We are only investigating the money laundering aspect. Predicate offense we are not touching. These are all scheduled offenses. We only scheduled offense we are entitled to. Vijay Badal says we are entitled. We have only searched the premises, nothing else. And search, section 17 says there has to be a predicate offense, that information, and then we have to suspect. Now all these officers, there is a conduit of how monies are flowing, so we are entitled to search and investigate and find evidence. Nothing else we have done. And
They have to follow 66(2), which is they have to give the information to the investigating agency. They can't do it. If they find an offence is there, they have to give information to the under 66(2) of the Act itself.
And detailed Panchnama, they are not harassed. Detailed Panchnama signed by...
One second, just see 66(2).
Everybody is treated with respect and dignity.
That's not the point. How can you rate the corporate office is the government office, Malas? If they have got anything against an individual, they can, Malas, deal with him. They can give us the information, we'll deal with him.
Large scale corruption is there. Look at what we have found.
What happens to the federal structure? What happens to the federal structure in this country? That every time any FIR lodged anywhere in the country, ED goes, Malas?
But kindly have a look.
Yeah, and we have lodged the FIR, not that they have lodged. Kindly see if the director or other 66(2), if the director or other authority.
My lords, may I have a look at?
Let me just read it. Sorry. If the director or other authority specified in subsection 1 is of the opinion on the basis of information or material in his possession that the provisions of any other law for the time being in force are contravened, then the director or such authority shall share that information with the concerned agency for necessary action. So if somebody has done any wrong, and we are the ones who raided, we are the ones who conducted an investigation, we are the ones who are raiding, finding out is why the retail shops are selling liquor at a higher price, We are the ones who do it. We are the ones who investigate. They come because an FIR is lodged by us. They get into the picture. But what happens to the federal structure? That means any FIR anywhere in the country,
up that prayer
the ED will come. And if they get information, they should give it to us under 66(2). We'll investigate. And 36 of the 41 have been closed. This is this disturbs the entire structure of the country. Under the CBI, you have to take permission. Under ED, anywhere, any FIR, anywhere in the country, you can just raid. And we are a government company. How do they raid my office?
But we have said...
How do they seize phones? How do they raid the office?
66(2), after the search, we have said no action. They are protected. Our cases, they are protected by the state. That's a different thing. But offence is prima facie made out on their own FIRs. Predicate offence is made out. It is not that ED is stepping in without there being an FIR registered by their own vigilance says an offence is made out. Large-scale corruption. Look at my FIR.
What happens to the federal structure?
That they gave that prayer.
What happens to the federal structure?
Federal structure, that prayer.
Law and order.
They give up.
The law and order.
162. They give up that prayer.
Law and order is within whose domain?
We are not doing law and order. There is no question of law and order in this case. There is no law and order. We only search.
So that means every FIR in the country they will search. Every FIR.
And we found incriminating evidence of large...
That they have to give to us. That they have to give to us.
17 does not make a search person accused.
And they are not accused. Section 17, they are not accused. We are only searched. That's all.
Search the corporate office. How can you search?
No,
seize our computers, seize our mobile phones. 60 hours of search. Women kept at 1 o'clock.
Details and chats, which if I produce, it will be shocking.
So now you take the phones, now you take the detailed chat. That means you can investigate the main offence itself.
We are not investigating the main offence. We are investigating not the predicate offence.
But then the proposition has to...
Would it not amount to encroachment upon the right of the state to investigate the matter?
No, because the right of the state to investigate the matter is open and they are doing it.
In every case, whenever you have a doubt that the state agency is not investigating the case properly, you go and interfere in that.
If that is so, my lords are right, but that is not the case. The state government itself has registered large number of FIRs.
They have registered, so therefore
they are investigating the predicate offence. I am not investigating the predicate offence.
So rate the individual, Manoj. How do they rate the office?
Simple thing.
I'm
It's
sorry.
not be a debate.
I'm sorry.
We are called
I'm sorry. I apologize.
Kindly have a look at section 2(1)(u). My lord, proceeds of crime emanating from a scheduled offence, they are entitled to investigate. And if there's no proceeds.
And what happens to 66(2)?
66(2) is if we find some other different offence, we can give the information. Here the scheduled offence is there, 47 FIRs. My learned friend says 47 FIRs. Look at the nature of FIRs. Look at how the corruption is rampant in these liquor shops and liquor distribution, controlled by tax. It is not that we have searched somebody who is a stranger.
Deal with them.
Yes, my lord. May I?
He has completed.
Yes, Manoj, I have, Manoj. Well, the proposition there.
I have my submission. Provided it is completed, I'll make my submission.
Yes, so therefore we have asked you not this be turned into a debate competition. You will say something, you will say something. Now you understood what are his submissions.
Now kindly have a look at the prayers.
He is basically on the federal structure.
Now kindly have a
when
look
the
at
state agency is investigating the matter.
Now kindly have a look at page, my lord. 162. You've given up that prayer.
Seize करके extract करके
gave it
So Rodi wants to argue something.
Well, he just wanted to say something.
I was just saying, Vinod, this question whether you can take somebody's phone and compulsorily extract information is a violation of Article 21, on which petitions are pending in this court with interim orders. Because in every case they say, no, give the phone, unlock it, and give me all information.
Those individuals
it
are not
contains large amount of information. You have no power, Miller, to do all this.
Those individuals
That's not
are
a
not before this
measure of
investigation.
investigation.
When your right of privacy is invaded.
Then they clone it. They can't do all that, Miller. My phone will have all kinds of information. You have to ask me something. You can't force me now, give my phone. Or sit inside your
All
mind
these
now.
questions
I'll
are
expect
taking a
everything.
batch of petitions which court has.
That's also a
ordered
question.
a committee to be appointed and look into those matters. These are different aspects also. But as far as those individuals whose so-called privacy is invaded are not before my lords.
They are my employees. Then 50 employees come to Supreme
There is
Court.
no petition.
You know, ladies are stopped for 40 hours in the office. They are told you can't go home. This is the nature
I
of
get
the
it. You can't claim privacy, my lord. It's settled, my lord. Can't claim. Now, my lords, we kindly have a look first, my lords, as far as the prayer is concerned. Page 162, my lord, that prayer has been given up.
Federalism. And it is replaced with 163.
My lord, sir, have it given the page.
62.
Amendment petition, my lords have got it?
Yes.
It's their amendment. For the reasons stated in the accompanying affidavit, the petition.
Now read down what is the amended prayer at page 163.
Yes, but kindly have a look at, yes, my lord.
No, that is deleted, but substituted by the prayers at page 163.
Now, what they gave up is important, but what they
No, what they gave up, but then what they want is also there at page
I'll
163.
read both, but I'll read both. I'm not running away from that. I'm not running away from it. Kindly have a look at what they had prayed for, my lord. Permit the petitioners to amend the writ petition by modifying the prayer to issue a writ of declaration or any other appropriate writ, order or direction in the nature of a writ of declaration to declare that the respondent shall not initiate, proceed, investigate, an inquiry, etc. under the provisions of PMLA against public servants of the against the public servants of the state government or the instrumentalities of the government of government without the consent of state government, and the Honorable Court may be pleased to issue appropriate directions and guidelines not to implement the provisions of PMLA 2002 except in consonance with the basic structure of federalism, separation of powers and other principles envisaged under the Constitution, and to pass such further orders that may be deemed fit and proper in the circumstances of the case and render justice. So this is what they have given us. Now kindly have a look, my lord, and then, my lord, what they've asked now is 163. My lord, read down and or read into the expression person occurring in section 21S of the PMLA Act and hold that same envisages a particular class and category to be included in its ambit, sweep and scope, and certainly does not extend to any authority, regulator or officer of central or state government. That means all public servants who are indulging in corruption will be outside the scope of the PMLA. If you read down the provision, that is their prayer. And Vijay Madan Lal, I will refer to Vijay Madan Lal in this context. Then the next, my lords, to hold and declare that the only obligation of the office of the state government under the Act is to assist the authorities in the enforcement thereof. Direct the respondent enforcement to call upon only those officers of the state who have been authorized and notified under section 54(1)(j) of the PMLA Act thereof by the central government to assist them for enforcement of the provisions thereof. To direct the respondents to request such assistance from the state government or its officers only in terms of section 54 and not under section 17 or 50, etc. To direct the respondents not to enter into or exercise any powers of search either in terms of section 17 of PMLA Act or at any premises of the government of the state of Tamil Nadu, be it any office or any corporation under it as well. Hold and declare the action of the respondents entering into the premises of Tamil Nadu State Marketing Corporation TASMAC to be illegal, unconstitutional, invalid, and accordingly set aside the proceedings carried out in person thereto. These are the prayers, my lord, that they have asked for. Now kindly have a look at section, what we have done, my lord. We have exercised innocuous powers under section 17. Kindly have a look at section 17. Section 17. And section 17, why this has been upheld in Vijay Madan Lal's case, my lord.
Not quite the corporation, government corporation.
Where it's section 17, my lord.
Nothing.
Yes. Where the director or any other officer not below the rank of deputy director, authorized by him for the purpose of this section on basis of information, in his possession has reason to believe the reasons for such belief to be recorded in writing. Those reasons are there, they're recorded in writing. That should be based on information. Information that any person, kindly note, not the person who is searched, but any person, kindly note that any person has committed an act which constitutes money laundering, or is in possession of proceeds of crime involved in money laundering, or is in possession of any records relating to money laundering, or is in possession of any property related to crime. But these are all disjuncting, or is used. Now kindly have a look, my lord. Reasons to believe were shown to the court. Reasons to believe are there. I've also extracted it in my affidavit. We have in our possession information that an offense of money laundering has been, any act has been done which constitutes money laundering. That information is on the basis of these 47 FIRs. 41 at that time, now 47. If those FIRs are perused, it will be crystal clear. Not recorded by us, recorded many of them by their vigilance, by their local police, which shows not only existence of predicate offense, but also shows money laundering. I'll take my lords to each of those FIRs and point out how the offense of money laundering is made out on a prima facie reading of the FIR itself without going. Therefore, the information was in existence that any person has committed an offense of money laundering.
And that finding is at para 31.
That finding is there in the Honorable High Court's judgment at para 31. Therefore, first part of 17 is complied with. Now, my lord, if that information is in your possession, when can you conduct a search? Kindly come to the latter part of this subsection, my lord. Then, subject to the rules made in that behalf, he may authorize any officer subordinate to him to enter and search any building, place, vessel, vehicle, or aircraft where he has reason to suspect that such records of proceeds of crime are kept.
That is what
Therefore, we can enter where we suspect that any record, etc., is kept. Then, when break open and lock a door, which is not done in this case, seize any record of property found as a result of this such search, marks of identification. Now, kindly have a look at. I'll skip those A to F. Then, my lord. Where is the subsection? Suspect. Now kindly have a look. A again, my lord. Enter and search any building, place, vessel, vehicle or aircraft where he has reason to suspect. So threshold is less. Reason to believe and reason to suspect are different. Information where reasons are to be recorded, or that information must be there. The type of information which should be there is that an offence has any of these paragraphs, A, B, C, any of these conditions, any one of these conditions are fulfilled, or not. 1, 2, or 3.
Information on the FIRs, which even transmit techniques discloses corruption. They say I'm a victim of that corruption, so the existence of the offence is there.
Exist.
Even it is not disputed by them. Can you please see the definition of person? Can you exclude a state government? In people of this court serve only safeguarding 197 at the stage of compliance.
It's a crime, I think that's a procedure.
So 2017 to 20 is the 6 messages and percentages.
Which document, which who's?
Therefore, what have we done, my lord? We information was with us, which was in the form of FIRs which disclosed money laundering. On the basis of that information, the reasons were recorded. Those reasons contained elaborately that offence of money laundering has been made. Is there reason to believe that money laundering has taken place, offence has been committed? Their FIRs, not ours. We did not. Therefore, my lords, therefore, those offices where they were shops, etc., of TASPAC, where this corruption had taken place. So we have reason to suspect, because the monies were also given to district managers, etc. Therefore, we have reason to suspect that we will get some evidence if the offices of TASPAC are searched for. We searched for and we found material. It may be in a given case that you may search a place, you may not find material, but that doesn't make the search.
That doesn't mean that your power is taken away.
Yes, that, my lords are right. Therefore, the search is for the purpose of gathering evidence. By the time we search, the evidence might, they have removed the evidence, they may, in a given case, the evidence may be removed. But did we wrongly suspect? Did we wrongly have reason to believe? Is a test which my lords will have to have a look at this particular case. And we have found, now I'll take my lords to the affidavit, what is the nature of evidence, what is the nature of information we had, the large-scale corruption which is there. That corruption is sought to be, my lord, crushed by making these arguments on federal. I am not saying whether this is a case of a large-scale economic offence where the officers concerned maybe has a patronage of the state, because the state is coming and protecting this. On the contrary, the state should be that yes, there are corrupt officers, we'll see that they are punished. That is not the attitude, or that is not the stand of the state. Now kindly look at the nature of FIRs and the nature of evidence that we have found.
Counter para 2 onwards.
I'll take my lords to the Panchnama. Independent Panchas were called, their officers present. There was no compulsion. Everything have been signed by their officials, high-ranking officials who were present, and the entire Panchnama has taken place under their watch. And it is during that Panchnama that this has been done. It is not as if that we went and ransacked offices. There have been cases where ED offices have been ransacked by state police. That's a different matter. But we have done it in a systematic and a very decent manner that the searches were conducted. The Panchnamas will reveal that. And the Panchnama will also reveal the type of nature of evidence that has been gathered, which would show rampant corruption. We've got evidence which would show. Therefore, now kindly have a look, my lords, at 2 or 3 things, our affidavit, my lords. Counter affidavit.
Yes.
In the, my lords are having the petition 7958, my lord. There is another, affidavits are almost similar, but 7958?
Yes, 795.
Yes, my lords. Kindly come to para 2 at page 1, brief facts of the case. As per the records of Department of Vigilance and Anti-Corruption, that is the state government department, multiple FIRs have been registered against employees and officers of TASMAC in the past years, and such malpractices, corruption ongoing in TASMAC. In past years, and such malpractice of corruption ongoing in TASMAC, list of 41 FIRs registered by DVAC against various officers, staff, employees were obtained by the ED and taken up for investigation. Now it is 47. Earlier it was 41. 46, I'm sorry. A perusal of those FIRs reveals rampant ongoing malpractices in TASMAC. FIRs were registered by DVAC, their entity, that in various joint surprise checkings, unaccounted cash was found in the retail vending shops, district managers' offices of TASMAC. And now we have found evidence for that, which would show money laundering. It was also alleged that officers at the level of district managers, senior regional managers are indulging in high level of corruption by collecting illegal gratification or bribe.
It is not as if the state agency was keeping silent and giving a Nelson's eye to all what was happening in the state.
My lords are correct. They are not keeping silent, but as a matter of fact, they are investigating the predicate side of the offence. And 37 are closed. Look at the type of 37 out of 40.
Look at the type of beer flatness.
No,
out of 41, you have closed on 37.
They have closed. They have closed. Therefore, they are not. Therefore, my lords put me a question: what is the state agency doing? They are closing one by one, finding means and ways to close all these high-level corruption cases. Predicate goes, therefore ED goes. Predicate offence goes, then ED goes. Therefore, they are trying to scuttle the proceedings, show the door to the ED. You go out because we are now controlling the door. 37 FIRs closed in a short time.
Let him say what. Let's not interfere.
This is not a case which I can understand, and this nature of these types of cases doesn't warrant interference. Ultimately, it's the prerogative of my lords.
No, it's not our prerogative. We have to decide in accordance with law.
Yes, madam. But ultimately, which may my lords look at it.
Vijay Madanlal is holding the bid.
Which may my lords look at it as a different thing. But in a case like this, my lord, there has to be, even if which is not so, even in a 50-50 case, my lords may have to look at in my favor. That's my submission. But it's not a case of that nature also. It's not. It's a case of rampant corruption and rampant.
Last 6 years, I have had an opportunity to go through many cases involving ED.
I am not,
because whatever we say
I am not saying that ED. I am not
Nowadays,
yes, I am not saying that ED is above board. There are officers and officers. There are officers and officers. I am not saying that. But in a case like
on the last time I said by mistake, it was reported everywhere.
The other side is more.
No, not other side.
When something is said in our favor, it's hardly reported. That's my grievance. That's my grievance.
Follow Mr. Sibal, then you also have your.
I want to follow, my lords. Therefore, now, my lords, may I read further, my lords?
Yes, sir. You have gone through, you can just highlight whatever you want to highlight.
My lord, kindly have a look at 5, my lords, at page 2. Regional managers TASMAC are indulging in collection of bribes for transfer and posting of TASMAC staff. So for this, will we not have to have a look at the offices and find out which office about what is the bribe taken, which are the officers transferred? This has to, therefore, we have to conduct a search in the TASMAC office. Otherwise, they will say that what type of investigation you have done. You have not even searched the most important place where you will get the evidence. There will be allegations made against the officer. Therefore, then my lords may kindly have a look, my lord. FIS has been registered on issue of daily bribes being paid to district managers, supervisors. FIS have been registered on the issue of TASMAC shops are collecting excess amount in the actual MRP. That staff are selling some foreign liquor which rarely come to in the market in an exorbitant price that are up to rupees 500 in excess of the actual price. Further, some supervisors also admitted that they are collecting excess amount than the MRP depending upon the brand of the liquor from 10 to 100. And they are not only collecting excess amount from the cash purchase but also collected excess amount even from customers who purchase the liquor through credit and debit cards. The FIRs are registered mainly under section 7, 12, 13 of the PC Act, which are also scheduled offences under the PMLA. In view of the above, search was conducted in terms of the provisions of the PMLA as per Pantnama of 8th month. The actual search that started at 13:55 hours on 6/3/25. Then, my lord, during the search course, one digital forensic examiner was called to clone one desktop and one mobile used in the DGM purchase office. Once imaging cloning was done in one 2 TB hard disk, and the working copy would be used for further investigation purposes. Search process ended in 3 days, during which the ED officers ensured that all employees were present and were given adequate rest. No staff, let alone any female staff, was forced to stay and were permitted to go home in the night, keeping all safety measures. Sri Jyoth Shankar DGM purchase and sales was permitted to leave premises at night, keeping in view his cardiac health. Search was also conducted and so and so. Then, my lords, but then, my lord, the preliminary submission.
So the other staff was kept for 3 days.
Yes. Search. No, nobody was kept for 3 days. I'll take my lordship.
But you said
the search
ended in 3 days, during which officer of the ED ensured that
no,
all employees who were present were given adequate rest.
Everyone given an option, they said we'll stay. I'll show. Let us have a look at the Panchnama. Not challenge. Panchnama, everyone, they said no, we want to stay. 99% left. I'm obliged, my lordship, put that question. Kindly have a look at the Panchnama now. 2 Panchnamas because 2 premises were searched, one on the upper floor and one on the lower floor. No? Page 112 of the counter. I'll come back to the counter again. Kindly have a look at page 112. Yeah. Special counter. I know that is. It's not there. Give me my copy. The 112, yes. Here.
Yes, 112.
112, R1. Now kindly have a look, my lord. From 11:55 a.m. of 6/3 to 8/3/25. Witnesses N. Bharat Kumar, employee of State Bank of India, and Tenali Subbaraman of State Bank of India, employee. Then kindly have a look. First paragraph, last 4 lines, the panchas were called. Then, my lord, kindly have a look at last 4 lines. The said authorization was already shown and explained to one Ramadurai Murugan, District Revenue Officer, General Manager so-and-so, and Sri Ramadurai Murugan, DRO, and signed the said authorization 11:55 hours as a token of having seen the same. Also put our signature so-and-so authorization. So it was authorization was shown to the employee who is the District Revenue Officer, high ranking, and General Manager. He signed it, so with authority. Then, my lord, kindly have a look at 113. Before the actual start of search and after conclusion of search, the said officer of Rajat Bharadwaj, Assistant Director, accompanying officer, see so-and-so, 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 and 2 enforcement persons offered their personal search, which was politely declined by Sri Ramadurai Murugan. The search premises, that is 5th floor of TASMAC office, was secured. Search premises consist of 1 cabin of Ramadurai Murugan, DRO, 1 cabin of Sri M. Jyoti Shankar, TGM purchase, and so-and-so, so-and-so. All the employees were asked to sit in the conference hall, and actual search started at 13:55 hours on 6th of March 25. Shri Jyoti Shankar Pachis entered the premises at around 16 hours and he was in a meeting which was held on the 4th floor of the same building. Shri Jyoti Shankar also signed the authorization as a token of having seen the same. During the course of search, one digital forensic examiner, Shri So-and-so FDL Labs, was called to image close one desktop and one mobile phone used by M. Jyoti Shankar, DGM Pachis, and one desktop used by Ramadurai Murugan, TRO, and two desktops of RV section used for compilation of sales data. This imaging closing of the was done on 1 2 TB hard disk, making so-and-so. Extraction of the same data was done in two separate TD hard disks. Their working copy will be used for that was done in their presence, not behind their backs. The search proceedings spanned 3 days, during which the officers of Directorate of Enforcement ensured that all the employees who were present during the search were given adequate rest. The search proceedings and recording statements were paused during the night, and majority of staff, except the key officers and helping staff, were allowed to go home for rest. Further, no female staff was forced to stay during the night and were allowed to go home in the night, keeping all safety measures. Further, Sri Ramadurai Murugan, along with some other employees, remained present throughout the entire search procedure. However, Sri M. Jyoti Shankar was permitted to leave premises at night due to concern regarding cardiac health. Further, the statement of Jyoti Shankar, so-and-so, and Sri LX manager was recorded under section 17 during the search. TASMAC has its offices 5th and 4th floor as well. So the staff was allowed to go to the 4th floor for collection of information documents that were asked during the statement. Further, some staff officers were also allowed to gather the information documents report that was asked during the statement from the 5 SRM senior regional managers, officers, 38 DM district managers over telephone. During the search proceedings on 7/3/25 in the daytime, one advocate, Shri Satish Kumar, standing counsel of TASMAC, entered the 5th floor without permission. He was politely asked to leave the premises. The search proceedings concluded at 8/3/25 at 11:40 hours. As a result of search, one master and one working copy and one mobile phone and 4 desktops have been seized as per annexure. Search was conducted in a peaceful and orderly manner, and no damage to person or property was caused during the course of the search. No coercion, threat or inducement, promise or any other external influence was used against the inmate. During the entire proceeding, no religious sentiments were hurt. Panchnama has been typed on the laptop bought by the officers of the Director of Enforcement. Same was read to us and found to be correctly typed. Now, this is signed not only by the searching officer, by the Panchas, and also by the officers of TASMAC, high-level officers, which endorses the correctness of the search and the proceedings recorded in the Panchnama. So it was not done in a hasty manner. It was not done in a disorderly manner. It was not. Nobody was threatened. Nobody was coerced. This then, my lord, as far as the Panchnama of the second premise is concerned, my lord, that my lords will find at page 116. This is the 4th. That was the 5th floor. Now this is the 4th floor. There are 2 punch witnesses, my lords, whose names are there. It will take some time, my lords.
How much?
At least an hour and a half, my lord. My learned friend saying, but I'll have to take my lords to an hour and a half, my lord, at least. Because I'll have to show case law, I'll have to show someone, even.
Continue tomorrow.
Yes. Tomorrow I have some difficulty, personal difficulty, my lord. Day after tomorrow. I am not coming to court tomorrow. That's my problem.
No, promise.
That's my problem.
Yeah. 2:30 today.
2:30 day after tomorrow. Today also I'm ready.
You require 1.5, you will get 1.5.
I was mentioning item 2. Item 2.
Yes, my lord, I am also mentioning item 2, my lord. We had mentioned it earlier, my lord. I'm requesting if it could be, my lord, after whenever it's convenient, but my lord, if it could be
First week of November, my lords. First week of November, best.
Even after the Lord, after Diwali, if it's possible, vacation.
Item 2 won't take much time, my lord. It's
That's all right.
Take about half an hour.
Requesting for a day.
Applications are in the nature of a review of a 11-year-old.
If you don't mind, we're just requesting.
What is the matter about?
That's the Goa Foundation, my lord, where that permanent fund, the scheme is.
But similar IA were dismissed earlier.
No, that's not correct.
Sit on court.
West Bengal OBC matter, your lordship was fixed it up today, the West Bengal OBC matter. Can it be taken up tomorrow, my lord? Okay.
So tomorrow we have I think, PM Tomorrow we are having.
Fourth.
Then whether it's day after, if it's possible, because that's.
We have kept that, service conditions of the chairman.
Then on reopening anytime, well, just said reopening then, well.
Now, just promise them post, so maybe.
Fifth, fine.
Next matter, item 21, I am being led by Mr. Devdutt Kamath. That is that duce matter of night shelters. NALSA had submitted its report. I filed my status report in response to that report. Mr. Devdutt Kamath is not here today. I am requesting a short adjournment. Next matter, item 21.
Item 30, the parties have agreed to go for try mediation, my lord. It will just be referred. They have agreed on a name also of a mediator. Other side is here. Yes, Mr. Gaurav Agarwal.
That's item
30.
Item number 5, your lord. It is to be listed on a non-miscellaneous day, your lord. So it can come up after vacation. No. From the other side as well.
I'll just point out, Manoj, this is that same reverse CIRP matter because this is that reverse CIRP matter where your lordships have given them time to conclude a project within a period of 15 months. It's been about 18 months over that period and they've not completed it. My entire CIRP process has been stopped because the home buyers have
appeared in that matter.
I'm sorry, Manoj?
So Sibal had appeared.
Mr. Sibal had also appeared. The same matter. Manoj, we are for the home buyers. We are the ones who are troubled, Manoj. If the statutory process would have gone around, we wouldn't have been here. So Manoj,
maybe because immediately after reopening, we have the hospital bench.
Yes, Your Lordship, may I just mention in this matter, item 5, I have moved an application for intervention as the sole secured creditor. So if your lordships are considering that today or on the next date, because what is being sought by the ex-management is now to charge what has been already given as security to me. So I have moved an intervention and an application for clarification. They are misusing your lordship's order.
Item 3, the constitution of the Kerala Cricket Association is to be amended. Only notice to be ordered to the BCCI. That's the only thing that will require.
Lord, item 32.
Lord, in the same matter. Lord, 29 is those pensioners' case. Lord, half of them have already died, Lord. Now they've come up with a new act of parliament. Lord, we have challenged that your lordships are hearing that matter. It's only a very short covered by several judgments. Lord, they can't change the basis of a judgment by saying that they can.
Lordships have reserved judgment. Item number 3, judgment. 17 Jalgaon DCC matter. Lord, I have filed written. Today it is 32.
We'll take it after Mr. Sibal.
Item number 3, my lord.
Not seen.
My lord, may I take the liberty of mentioning before the special bench, there are two civil appeals which have been tagged along with this contempt, which arise from the NCDRC. This court had directed monies to be deposited. Sahara India Commercial Corporation is the respondent. We have entered into a settlement agreement for the home buyers that will simply withdraw the money and close the matters. My only request is, my lord, the matters may be listed. I'm mentioning before this bench because somehow it has been tagged along here.
So there are
Grateful.
there are a large number of claimants. Ultimately, your lordship will have to decide.
Only
Today, for example, some employees of Sahara have made applications. These are small claims. Sahara will have to verify and then we can take.
I'm only praying list the matter, your lordship may see.
Whenever next time the bench is being assembled, it will be listed. Today it can't be.
No, not today. I'm just praying for listing. I'll give the number. Your lordship may list it whenever the bench sits next. That's all I'm asking.
My lord, may I be permitted to withdraw an IA number 21178?
May I have a word in this, Malas, because we are presenting the plan, Malas.
But before that,
You are appealing for who?
I'm paying for Sahara, Malas.
To examine the claims of those workers and all.
That's right. That's why we have suggested a process through which that can be done, Malas.
I number 7 and 10. They're related to employees.
We are suggesting that setting up.
Number 7 and 10.
only 1 minute, my lords. If I am hurt, my lord, I am not coming in the way of any plan being considered. I cannot. But this may, my lord, this appears to be a good suggestion, subject to, my lord, various factors gone into. But government also, the central government also may have to examine and put its the thought before your lordships. Lord, the request is that if your lordships can consider implementing the secretary finance and secretary cooperative societies. There is a cooperation department now because there are some cooperative societies which are, Lord, they have invested through members, etc. So, my lord, we can also, my lord, present our picture.
And who is appealing for SEBI?
Not, sir. I appear for SEBI.
You will also have to examine the proposal.
Lord, there is as far as the proposal is concerned, my lord, but other than that, about the salaries, your lordship is asking about the salaries. Your lordship is asking me about the salaries, etc., my lord?
No, these proposals.
Proposals, right, your lordship. There's already orders passed by this honorable court, my lord, that the properties can be sold by Saharas not less than 90% of the market rate. That is because, my lord, SEBI, initially what happened was SEBI was tasked with the job of disposing of the properties. We couldn't do it, my lord, because of the many, my lord Justice Sundresh should know, because lordship was on the bench which heard this matter last. We could not do it. And therefore, my lord, Saharas on their own plea, my lord, in fact, my learned friend, Mr. Kapil Sibid had made the plea and it was allowed. This honorable court said you can sell all properties not less than 90%. My lord, we are not into, there's no requirement for us to examine any proposal, my lord. That is, if they are in compliance with your lordship's directions, that is all has to be seen, my lord.
We will have some objection on. We are the buyers of those 3 buyers. Since they are also already the taxman, let them say. But some of us have got decrees in our favor. Some of us have got A balance. Those properties are listed. I appear for 3 buyers. Out of 75 acre, 50 already registry is done. That is also included in that. Another one, I have been given power of attorney fighting the revenue litigation, getting it cleared. I am doing that, paid 10 crore rupees. So, most of those properties, maybe I am appearing only for 3. Maybe there would be others also. As there are others. And nothing is disclosed. And my lord, the tenor of the application, if my lord sees that everybody has to come here, all disputes will also.
So may I make a suggestion? My suggestion is this, that at least by 4 orders, your lordships have said that Sahara must first deposit the principal amount, which is about 25,000 crores and odd. As on today, they are in deficit about 9,000 crore.
9481.
9481. 9,000 crores, 481. That is the deficit. Now I said.
That was about 15,000 crores.
16,300.
16,000. Now, as per the original order of
the amount which is being separately disbursed through the committee appointed by this court.
No, my lord. The total liability, principal amount
under the orders of your lordship.
The first judgment, my lord, which is of August 2012, the initial judgment.
So there is a committee constituted by, headed by this court. Constituted
No,
by
there is no committee, my lord. There is no committee, my lord. The Justice Agarwal, the retired judge of this honorable court, was appointed to oversee the SEBI effecting the refunds. According to SEBI, all refunds which we have done, and we have also moved in applications before your lordship, saying that we have completed our.
Pointing out something.
Yes.
Mr. Solicitor General will be able to tell you more detail.
Yes, my lord.
About a couple of days back, the matter came where already there was an order by this court to disburse 5,000.
That's in a connected matter, my lord.
The cooperative society.
Cooperative society. That's a different matter.
As far as that matter,
This gratuity or deficit is other than that.
Other than that, that is a cooperative society, my lord. We are concerned only with two companies.
No,
Sahara
that's
India
not.
Real Estate.
It was adjusted with a fund. That is already SEBI Sahara fund. That cooperative societies, the payment was made under the SEBI Sahara fund. Anyway, if your lordship have gone through this application, Mullahs, the 9,000 crores my learned friend is talking about will be deposited, Mullahs. In fact, more than
may I make my suggestion?
more than that.
Not today, Mr. Sipal. Let the Union of India and
Yes,
all the stakeholders.
We all have.
First of all.
I have one suggestion. This application has 88 properties that they wish to sell. Of those 88 properties, several of us have applications, some listed, some unlisted, where we say either that they were sold to us or they are aggrieved in some other manner because there are judicial
the power of attorney.
correct. So there are judicial, there are proceedings, there are agreements, there are sale deeds. One suggestion is, if each of us can intimate amicus among those 88, which are our application numbers, the Lordship may look at that, which will leave a residue which they can get their orders from this court. That's my suggestion.
We have proposed an oversight committee which should look into each of these claims and then decide on the matter instead of your lordships being troubled on a daily basis.
No,
that's
but
the proposal.
prayer says everything will
That's
be
the
this
proposal.
court. And that's the problem.
One matter, there is a civil suit going on out of 75 acres for 16 acres. I am also dealing with that. So, Malad, they are saying that everything will go. So, Malad, we don't know what all rights and wherever it will go.
Question is, who will decide?
That's all.
That's the question. There, someone will have to decide. It normally cannot be a lordship's there.
That's better, I think, the central government and the learned amicus, you apply your mind to the application.
Exactly.
And also.
So if your lordship permits me, consider my suggestion.
Take into consideration their objections because they say that they have a right in respect of certain properties. So whether such properties also could be a part of.
So first Sahara will have to deposit that now 9,000 crores and not. That is point one.
No, but that he is saying that once these properties are disposed of, he will be depositing more than what the.
No, but in fact, the person who is buying it is going to deposit 12,000 crores.
So
not just
in that
9.
respect only I am making my suggestion. If my learned friend permits me to put it across. So my suggestion is first that principal amount of 9,000 and odd crores Sahara will pay. Then the question is of interest. That under the original order of your lordship's court, they had to pay it with 15% interest. But this question is kept open by subsequent orders that your lordship will have to decide. Once your lordship decides the question of interest and that amount comes to the kitty, then whether Sahara sells it for 2 rupees or 10 rupees is something with which we may not.
Interest to be paid to whom? Where are the depositors to whom the interest is to be paid? My learned friend, but who is going to get the interest? What are you talking about?
Lord, as far as
Interest
the-
to whom?
as
There are
far
no
as-
depositors before
That's
the
the order of the court.
Or no, the court says this will be decided later. Don't say
That's
that.
what I'm saying.
My lord, as far as SEBI is concerned, all the investors have been repaid. Those who are there, and we have moved an
investors are
application
found
saying
with them.
in accordance with the judgment, the money should go to the central government. Because that is what the judgment says. If there are no more investors, the balance should be handed over to the government of India.
That's a question
So, my
of
lord, the
debate.
government of India should be heard.
India is also a very
Yes, my lord.
stakeholder.
Yes, my lord.
Them also examine
Yes,
the process.
in fact, they should be permitted to intervene, my lord, because
CJ has pointed
Yes,
out
madam.
that let the Union of
yes,
India
Union of India should be there, my
India
lord.
also can examine.
Yes.
The decree, sir, the decree as it stands, 15% interest.
Only if there are depositors to be found, not otherwise.
Lords, may I suggest something, Lord? May I be? I have filed an application, Lord, where I want to buy 12 of the properties, and I have given details of that. Now, Mr. Sibbal's proposal, whether it includes that or not, we don't know. But we are people, Lord, these lands are situated in different states, Tamil Nadu, in Karnataka, in Kerala, in Milord, Orissa, and other places. So we have given details of that. We wrote to them, Milord, about it, that we are wanting to purchase, and Milord, they never answered back. Therefore, we have had to make this application before my Lord.
So you can't compel a seller to sell it to you.
No, I am not saying compel, but I am not saying that I am willing to match any offer.
I think the offer is holistic offer. Offer is holistic. So therefore the focus will also be holistic.
Milord, may I say something? Milord,
I am willing to match any offer, Milord. That I am not.
Offer can't be in court, Mr. Kumar. There has to be some. It has to be public domain.
I am not.
And there are maybe there are other competitors, other bidders who might offer maybe 10 times more than you.
So therefore, not that's what I am saying.
That's what the learned solicitor also says, that there has to be some forum where all these issues will be decided, and it can't be this court.
I bow down, Lord. So
that is part of the proposal, Manoj, an oversight committee.
The problem is this. One is with respect to the competing interests of all the parties. What is stay, some will be agreement holder, power holders, and sale deed, pending dispute, all those things. Second is whether we have to accept the scheme and then go for a one purchaser or in piecemeal. What you are saying is piecemeal. So these are the issues we have to consider.
Right. Yes.
Now the problem with what you are saying is that now there it will be endless.
Correct.
Now once you
if there are 100 properties, 100, so prima facie, his proposal appears to be subject to the claims of the others, wherein the rights have already been crystallized.
Value maximization would be the idea.
I'm only on the maximization part.
Yes, maximization that will take care of.
What we are also asking for is about 700 acres of land, Milord.
No, so therefore
it's not a small piece of land, but spread over different.
I don't know what happened in that golden forest. We were appearing in.
Yes, Lord. I was one of the parties who had given that.
Well, it's almost everybody appears in it. Almost everybody appears in it.
For the other
Yes, we were. I think this is the Dipankar Datta. So there also we had directed the income tax authorities to value the property, and then we had said that selling property in piecemeal, it's unmanageable. Therefore, we had directed that the consolidated sale of all the property should be done, and it should be by tender process.
My lords have held that, my lords, at least state-wise they can do that.
Fragment sale.
Because Hyderabad, it's been unencumbered. Your lordships have.
That prayer, when I was sitting, I had rejected that prayer. We had said that there has to be only one sale.
I have something.
May I bring?
I have the 90th. Well, there are 88 properties which Mr. Sibbal is proposing. I mean the 89th property which is not concerning the.
No, it includes the 89th.
No, it is not. It doesn't. It doesn't. We have checked up your application. Where, my lord, the parties have settled in a mediation which happened in this court. So that is awaiting my lord's approval, my lord. The mediation report is here. That may also be.
That's been in sealed cover.
Yeah, no problem.
And it was based on your lordship's direction in January.
Except crystallized, those will have to be left out. Even There's one other aspect which is not only about third-party rights. Some lands cannot be sold. For example, there are two which are wetlands, where anyway there is no question of selling that land. That land could never have been subject matter of this list.
True.
There is another where it's agricultural land.
Even if he purchases the wetlands, it is his problem. He will not be entitled to
construction
or do any construction.
Our order will not give it clean check to them.
Unless.
The problem is when your lordships give you a blessing to 88, they will sell.
If somebody wants to purchase, knowing that he can't do anything on that.
Correct.
Lordship, may I am one of the two surviving directors, Madam Vandana Bhargav. Lordship, my writ petition is of 2018, and Lordship, it has been tagged with a contempt petition. Unfortunately, in today's list, it is not mentioned. Writ petition civil 877, oblique Lordship 2018. So it is pending for the past 8 years, Your Lordship. And my personal assets have been attached, Lordship, entirely for the past, Lordship, since 2013. Contrary to, if I may submit with greatest of respect, contrary to the judgment passed by this Honorable Court, this may kindly be disposed of, Your Lordship, or detagged with the contempt, so that, Lordship, I am 73-year-old already. Madam, I am one of the 2 surviving lady directors of the group. And my personal assets have been attached. And my passport has been attached for 14 years, 2013 to 2026. If my learned friends permit me, my suggestion is this: I'll put it in writing how this tangle can be resolved. I'll put it in writing, let my learned friends respond to it. My suggestion is this: that first, this deficit amount, Sahara has to deposit. Second, the question of interest, Your Lordships will decide. Third, as far as the third party claims are concerned, which are already crystallized, something will have to be done about that. Either Sahara settles or the new buyer wants to settle it. As far as claims which are not yet crystallized, they have their own remedies, they can adopt those remedies. I'll put all these suggestions in paper and make it available to anyone who wants to.
That is better.
And
My lord, the implies who has not been paid, my lord, at least their request has to be considered, my lord. In the earlier application, my lord, Honorable Justice Surikant has passed an order, my lord, in which all the implies they were paid from the Sahara Sevi account, my lord. That is around 10,000 crore is lying, my lord. They are contesting for thousands of crores. They are forgetting out 100 crores, my lord. Yes, my lord.
Small intelligence at my
For the employees, there are 150 employees, etc.
Yes, my lord.
Judges speak.
You have already ordered to pay to.
My lord, the one set of employees has been paid, my lord. The another set of employees who were working with the Sahara Media, my lord, they were not paid, my lord. Their entire amount is pending, my lord. That has to be cleared, my lord. This is very small amount. Very small amount, my lord. This IA number 10, my lord. IA 9 and 10, my lord. IA 9 and 10, my lord. Hardly 190 employees are there, my lord.
I will take care of these IAs which are there
By the employees.
My lord, the IA doesn't have any issue, my lord. Implies issue, my lord.
Small request. I am not concerned with sale and purchase of any of the properties. Notes by the main order, Your Lordships, clause number 8 has directed all the proceedings to be kept in abeyance which are pending before different forums. That order, Your Lordships, in 2024 has relaxed to certain extent, meaning thereby, my lords, those who have already approached the relevant forums, maybe a civil law or a commercial law before NCLT, those proceedings are allowed to be proceeded further. That order, Your Lordships, would get at page number 36 of my IA. That order is already there, so I just want that liberty. My application may be allowed. My proceedings under section 9, which are filed before Mumbai NCLT, they may be permitted to be proceeded further. If Your Lordships has the chart which has been submitted by the learned amicus, my application is mentioned as number 6, my lords.
IA number 10, my lord. 9 and 10, my lord, for implies salary issue, my lord.
Yes, my lords, it is only that.
IA number 9 and 10.
And then there's another IM law 74972, which is
Granted
listed
liberty
today.
earlier,
May I suggest, Your Lord,
that wherever proceedings have been initiated, they should not.
My lord, they are suffering for years, my lord.
And that direction has been relaxed. So I'm just requesting for relaxation to that extent.
Lord, may I just say something, Lord?
I have listed IA.
Lord, I've been in this matter now for 14 years. Now, Lord, I think basically it can be divided into 3 parts. One is making the deficit. Secondly, sale of properties, and then dealing with all the miscellaneous applications. Now, Lord, there are 2 things. There are 88 properties. I don't think there is a dispute regarding all properties. If the Sahara what happened is Sahara companies have the liberty to sell any property of their choice. It should be 90% of the guideline value or circle rate. That's all. They can do whatever they want. Now, out of the 88 properties, not all are in dispute. So if they can segregate those which are clean properties, so to speak, that can be taken up and sold, and that 9,000 deficit can be made first straight away. That's my suggestion, my lord. And then Lordship will fix a date and dispose of the IAs or employees, etc. separately. That's my suggestion. And
Right,
one
my
more
lord,
thing, they have given a seal.
Employees IA, my lord, can be disposed today itself, my lord. There is nothing.
It's allowed.
Yes.
Lord, there are some properties which are not owned by Sahara at all. For instance,
Let it finish.
so may I?
I'm sorry.
No, I'm not finished, my lord. What I'm submitting is, my lord, what happened was the properties are first given to SEBI to sell. But there are so many problems and encumbrances. We appointed State Bank, real estate, we could not make it. Then finally the court said, Sara, you sell whatever you want and just report to the court that we have sold this property at 90%. That's all. Now, according to Mr. Sibal Vinod, there are some 88 properties which are now the subject matter before your lordship. I don't think everything is in dispute. What are not in dispute can be put into one bucket and disposed of. Water in dispute can be placed before your lordship and sorted out. Somebody has got this claim, that claim, or that committee which your lordship is referring. So, my lord, one thing is, Asha, there is one more. There is one seal cover in the Supreme Court where Sara has given additional properties which are worth 1,60,000 crores. That's what they have said in the affidavit. One cover is before your lordship. Even some of those properties can be sold. Just 9,000 crores are left. My lord. Once 9,000 crores is paid, now SEBI tried to identify the debenture holders. First of all, there is no deposit here. It's a debenture holder. We could not locate the debenture holder. Supreme Court has said if you can't locate the debenture holder, give the money back to the government. That's all.
How can that be? Anyway, be that as it may, Mother,
May I just add
my
one
learned
thing?
friends is, Mother, if I start selling this property, there are any number of claims I have not been able to. I've got a buyer now, Mother, who is willing to buy everything. Now, if he says that you allow me to sell, Mother, how will I sell? It is attached by ED. I can't have a single property.
I am Adani Properties. I have made a comprehensive offer, my lord, which is before your lordships in a sealed cover. I don't know the numbers myself, my lord. Lord, I have made an offer of buying all the properties. Otherwise, this litigation is endless. My lord, one chunk at Versova was tried to be sold. There are decrees, there are attachments, there are injunctions. I have made, my lord, a comprehensive offer. It is my request, my lord. I came across an order passed by Justice Suryakant's bench, my lord, some time back, where a husband and wife, my lord, two people came and wanting to sell all their properties. I think my lord should pass an order to whatever. This is what I am proposing here.
So we have not received this.
That is Keshav Rao Bhapkar's matter. My lord, Justice Suryakant's bench has passed a very detailed.
Where there were about 400 or 500 properties.
Correct. So, my lord, the idea is only the otherwise, my lord, it's impossible. This struggle will go on. 12, 13 years have gone by. My suggestion is, your lordship may, my lord, send it to a committee, which, my lord, the solicitor may appoint, suggest, the court may suggest. They can examine it. Because, my lord, I am also saying that I will take it with these kind of claims also. Otherwise, my lord, if everything has to be clean and without anything, then Mr. Sibal's client, my lord, will spend maybe one or two.
What about the properties where the rights are crystallized?
Exactly.
So that means the committee will decide how to deal with it.
So the committee will look into it
and finish off.
Let the solicitor take instructions.
Yes, not the committee can say that out of 500 properties, 10 or 20 have already taken care of crystallized decrees.
May I just give one example?
One minute.
They may be
IA number 232892 of 2025. This application is filed by Sahara India Real Estate Corporation Limited for certain direct.
No, it's not filed by Sahara India Commercial Corporation Limited. IAs are by.
No, so Sahara India Real Estate Corporation Limited.
No, that's the main company, my lord. That's the main company. The application, lordship will see application 232656665. The applicant is Sahara India Commercial Corporation.
That's correct. That's correct.
What is your IA?
Because IA is 232892.
Yeah, there is no applicant, my lord. In 23892, there is no applicant. They just say applicants.
There are two IAs, Mother. My management is not.
Lordship will just take 232665. It is by Sahara India Commercial Corporation Limited.
That's
it is
correct.
not in the main dispute at all here.
There's another application.
Sorry.
And the other application is 2328925. There is no mention of who's the applicant.
232665.
May make a lordship just have a look at judgment of Justice Suryakant. Justice Suryakant's judgment. It sets out, my lord, some procedure. It may help your lordship, lord, in formulating this order.
Real estate.
It may help your lordship formulating this order.
Probably,
yes.
Where the MPID court started selling the property,
right,
and virtually those were going in peanuts.
So, my lord, I thought this was the closest we could get. The lordship will set out the prayers. See the first prayer, my lord, direction to so and so to liquidate the attached assets in 6 months, then direct distribution to genuine investors, etc., etc. Then, my lord, the court goes into details. Companies are mentioned. SEBI, registrar companies, everybody is here. Then, my lord, the lordship will find page 5, pages are at the bottom. Page 5, subclause G. There, the lordship will find penalties on those companies, recovery proceedings of 3,000 crores, immovable properties attached by Maharashtra Milord Protection of Depositors Act, Mumbai. Then Milord, next page, MPID and SEBI attached, then FIRs, Milord, in different states. And then Milord, paragraph 4, page 8 may be seen. Your Lordship then culled out, Milord, what will the questions be? Location of properties, encumbrance, physical possession, disputes, market value, liens, machinery to be evolved, mandatory procedure.
When is it?
This is by the company which has entered into terms
Now, Milord,
by this application.
That's all I can say. That.
now, Milord, para 7. That's the para 7 at page 10, Milord, at the bottom. Keeping these exceptional peculiar circumstances in view, we deem it fit to invoke a clause 142. So as to do complete justice, we constitute a committee. Justice Bhatt, Justice Satish Chandra of Allahabad, SEBI, states, the Registrar, Milord, Deputy Secretary Home, Maharashtra, who's in charge of UOW, on the next page. Then they can have, Milord, engineers, accountants, etc. They can obtain all documents, prepare a database. Then, Milord, SEBI will also be there. The committee will take steps. Milord, to properties are entrusted, encumbered, etc. All this, Milord, will be done. Something like this, Milord.
Union and the amicus filed their
Exactly.
Right. I just wanted to, Milord, inform the bench that this is the closest that I could get in terms of an order, Milord, of this kind of a problem.
So we will consider.
My lord. That's all I wanted.
There are several other IAs also which are not listed.
May I say something, Milord?
All IAs.
If everybody stops, then we will start depleting.
My lord, one additional request, my lord, at the end of it, I am the 89th property, my lord, where parties have settled. There's a mediation report pending before this court. Mr. Naidu is appearing.
I have no problems.
Buyer. He's for
There's a mediation and I have no
For
problem.
home buyers have.
I am for the home buyer.
Have you examined the 89th property?
Which property?
The property in Coimbatore.
Because the 89th property will be
That's
not the 88.
That's in Coimbatore millets, put in sealed cover and.
Some of them are subject matter.
We have already deposited part of the
What I am
amount.
suggesting is, as on today, there are 60 and odd IAs which are pending for consideration. Now we will have to prepare a tabulated statement about each IA, and then it is possible for us to collate how many matters are how many properties are subject matter of dispute in your lordship's court. Because ultimately everything has to be resolved. All these 60 applications have to be put an end to. Otherwise it is endless.
That is the suggestion that Mr. Solicitor as well as Mr. Sibal says that.
Therefore I suggested
I will be done by some other court because this court can't decide all these.
Exactly. Therefore I suggested that once the Sahara pays the principal amount and the
How will I pay?
How many times you will say the same thing, Mr. Nabde? From where will they get the amount? If they don't sell the property, so how will the amount come?
So they say in the sealed
There is a list of properties in the sealed cover.
So they have put some properties in sealed cover which nobody knows. But some of those properties.
Before your lordship.
Now, how can we accept that? That's something somebody has offered them. Why should we accept it right now? Unless we heard the other party, that 9,000 you are asking, that somebody has offered to them.
So the point today is very
That will imply the amount that as if you are accepting that itself. We don't want to do that.
My apologies, but it is not. These are properties over and above the 88 properties. These are separate properties in a sealed cover which are worth
There is
1 lakh.
nothing. We are not entitled to sell a thing, my lords. Moment we try and sell, we've tried for years and years. We've not been able, my lord knows about it. Yes, it has to be sold together in a basket. Otherwise, it won't be sold. That is why you have, remember what happened in Warsaw, my lords? 5,000 crores, we couldn't, the deal couldn't go through.
But Sahara itself has negotiated.
Every claim is
each other. Otherwise,
once the decretal amount is secured, what they do with their property.
Okay.
for people whom I am appearing, they are willing to deposit the balance consideration, everything is made, agreement to sell, amount is there. So people like us, we may deposit and any order pass ballot on that aspect.
How do you know these documents are genuine document, bogus document, fraudulent document? How do you know?
Well, we have made the payment in the SEBI account and to Sahara. Well, as the account transfer is there.
Leave it.
Well, as that is there. So pay the balance, the ballot is direct.
Yes, thank you. The application number 232665 of 2025. This application has been filed by the Sahara India Commercial Corporation Limited, taking various directions, including approving the transaction as contemplated under the term sheet dated 6 October 2025, executed between the applicant and the Adani Properties Private Limited. Several other directions have been got. Correct. The learned Solicitor General of India said that it will be appropriate that before considering the claims made in the application, the Union of India, through Ministry of Finance, as well as the Ministry of Cooperation, should be heard. We therefore direct the applicant to implement the Union of India to Ministry of Finance and Ministry of Cooperation as non-applicant to the application. Right. We further find that it will be appropriate that the Union of India may several claims have been raised before us by various interveners. It is submitted that the application also consists certain properties in respect of which the rights have been crystallized between certain parties, crystallized in favor of certain parties. The learned solicitor also but that the competing claims will have to be considered before some forum. However, it will not be possible for this court to consider each of the claims. Correct. After the learned amicus states that the Sahara India Sahara India Commercial Corporation to be first directed to deposit the balance amount of 9,000.
Sorry, but not Sahara India.
Sahara
India Real Estate and Sahara Housing.
Housing, these two companies, Sahara Housing and Sahara Real Estate.
And Sahara Housing. Sorry, brother.
9,481.
Amount is 9,481.
No, there's some dispute on that. Therefore, let's say
approximately.
Would we consider the application? It will be appropriate that the Union of India, the SEBI, and the learned amicus examines who will tabulate the rival claims in respect of.
It's already tabulated.
You all can give it to amicus, no detailed
How will that happen? Amicus has been tabulating it, my lord. A detailed tabulation he has already prepared.
Amicus can do it.
Some chartered accountant.
Tabulation then.
Well, my request is, it should be done by the Oversight Committee of Claims or what claim.
Colleagues to go through this exercise. It can be vetted by you.
Yes.
So there are 88 properties, but the last item says other properties where there is no description. in their IA, they have referred to 88 properties.
In respect of 88 properties, somebody can apply the mine and find out if there are any claims with regard to that.
Correct, correct.
Can the Union of India do it?
Since the Sahara must
It
disclose.
would be disputed. Instead, if the amicus does it, there may be some objections filed by some of the applicants which may not be relatable to 88.
88.
Yes. So he would have the larger picture.
The Sahara must disclose whether there are any
Yes.
third-party claims.
No, Sahara was bound to do that because they know.
So we don't. I mean, some of these things we don't know. In fact, we have no idea. Some of these things.
No, but if you have sold, they're more.
No, Manas, we have not sold. Manas, your lordship must understand the employees here. The employees here have been dealing with it. We are not involved in it. So we have ourselves come to light and we ourselves filed some applications. So there's a problem, Manas. Therefore, that's why the agreement says other properties, whatever, because we don't want even a single part of it. So as and when that are discovered, Manas, it will be dealt with.
Well, it's the problem with Sahara is every time they change a stand.
Yeah.
Initially, my lords permitted them, as Mr. Datre has said, if it's 90% circuit rate, you can negotiate along with the affected parties and settle. For example, Coimbatore property millets, they negotiated along with the home buyers, and we have had a settlement, and there's been placed before lordships advance paid into SEBI's kitty. Now they say that no, let it be in whole hog.
No, I have not changed. I have said yes, in fact, on the contrary.
Yes, you have agreed and you have signed along with those who have got the stakeholders.
I've said yes.
Even before it's also
I said yes.
Yes,
I don't know why you haven't heard me.
So the normal course in execution of a
You
decree.
can now, if you nominate one of your juniors to collect that information.
Yes.
So we can collect it only on the basis of pending IA.
Mr. Nabde, because all these applicants, interveners or applicants who have applied, they must have given a copy to your office.
Yes, some IAs,
Based upon
60
that-
IAs we have got.
Based upon that, you please depute one of your assisting counsel who can be an assistant.
Yes, we'll do. That is what I suggested initially. That third party claim.
Person will prepare. One is the list of the undisputed title, second will be disputed, and third can be doubtful. Doubtful
Also, my
means
lord,
that
we
there
could
is
say-
on the face of document appears to be doubtful.
But as I indicated to your lordship, that the last item in their list which Sahara has given, it says other properties where there is no description.
We'll come to that later.
Process. In the process, you can ask the Sahara to provide you the information wherever they provide.
Have it, we provide.
Very well.
Put a remark on them that this information is not available.
Very well.
And that chart, a collated information can be broken.
So long as it becomes clear that whatever Adani is buying comes with whatever claims that there are, and those claims can be adjudicated by some forum, there should be no problem. So for instance, in my lord clients, they own the land. They had an agreement with Sahara to develop it. So, and Sahara was to get 90%. Now they have a certain claim. They're saying that the agreement is gone, etc. Some forum will adjudicate on that. Otherwise, we have no problem. Instead of Sahara, Adani will come. That is not an issue.
Court decree in his favor. Why should he then again go for a claim?
What I'm
It
suggesting,
will be endless.
let all these
Therefore, all
applicants,
this will have to be sorted by law.
let all these applicants lodge their claims in a tabulated form with me,
Yes.
and I will prepare a consolidated statement. Otherwise, it is haywire.
You can be assisted by a team. You got, then it's fine.
More
You can
competent
add to
than
the
me.
team. You can add to the team.
My lord, my issue is completely different, my lord.
Kochi property, we are the investor, not buyer. We have invested since 2014. 10 years have passed. Not buyers, we are paying to the bank installment. And we are waiting for the flats. 50 crores.
IA 9 and 10 for salaries, my lord, the employees' salary.
Now you have said that at least 10 times. But we find that before we consider the application, it will be appropriate that the parties who claim to have any rights in respect of any of the properties listed in the application does lodge their claim before the learned abacus person. We request the abacus abacus to nominate an assisting counsel who shall collect the said information in a chart showing the properties where there is no dispute, the properties where the rights are crystallized, and the properties which are under the shadow of doubt.
And also, Lord may also include settled properties. There's only one settled properties.
That is crystallized.
There's a mediation report.
Let them seek a response from us before they finalize, because we also must know.
My other suggestion is that today we have number of applicants before the court. Now, if there is some other third party that Sahara should disclose.
No, if we know, we certainly disclose. I know. Why are you saying? But we should be allowed to respond to that.
Sahara, India's one, so would also be entitled to give its input.
Yes, exactly.
The learned abacus. In addition, we request the Union of India, the learned abacus, as well as the SEBI, to respond to the prayers made in the IA paragraph. So far, the IA's concerning claim of the workers, claim of the employees is concerned, but we guide the Sahara to examine their claim and respond to the same on the next date. Please.
Your Lordship, I have filed an IA which has not been listed. Your Lordship, this IA was.
You already said that we are not said A employee or B employee. We have said that IA concerning the claims of the employees.
Your Lordship,
My lords, may I be permitted to withdraw an IA? My lords, may I be permitted to withdraw an IA for intervention, my lords? It will reduce the cost.
Whoever wants to withdraw, they give their names. You also want to withdraw.
Your Lordship, my IA is not listed. It was actually, the civil decree has been passed in my favor, but the execution is pending due to the order of this honorable court, Your Lordship.
Okay, we will consider. You also lodge your claim with the learned amicus.
I have already supplied the copy, Your Lordship. My IA may be listed on the next date, Your Lordship.
As far as my offer is concerned, Lord, the amicus will consider and Sahara will.
That we will consider. Whether the properties are to be permitted to be sold in a piecemeal or in one block.
That's right.
I am also asking for 700 acres of land, Lord.
Maybe we will decide whether we have to follow that Golden Forest order or some other order.
Exactly.
I am willing to match the offer.
Lordships.
If you are willing to match the offer, then match the offer for the entire property.
Not the 88 properties. But
Lordships, there are certain IAs regarding the 88 properties that are not yet listed. Lordships may clarify that those IAs be also be listed, my lords.
20, Lordship. Number 20, Lordship, purchase of property owned by subsidiary company of Sahara Group, Lordship.
Whoever has any claim in respect of any of those property, you may give a.
There's an encumbrance in that property, Lordship.
So there is no encumbrance, then it will come in.
Lordships may clarify irrespective of whether their IA is listed today or not.
Lords, in the Lords, in the IAS for the employees, may I, my lords, only.
Learned solicitor, when do you want it?
Maybe 4 weeks, my lord, because the learned amicus also will need that much time, my lords.
I just want that you click under section 9, you can proceed further. Lordships have already granted that in just 12.
Same clarification, Malas, I am seeking in seal number 23 and 24, Malas. 4 weeks. Listed IA, Malas.
Employee issue, my lord, maybe.
These applications on the next day, whether they can be granted liberty.
The commercial terms are not disclosed.
No, I'm talking about the IA of the others.
Yes, Malas, serial number 23 and 24.
My lord, employee issue order has been passed earlier, my lord. Similar order has to be passed, my lord.
It is dated 3rd September and
it has to be cleared from Sahara SEBI account, my lord.
We'll have to file a reply to all that.
Today.
And it's very small amount, my
lordships.
Where Mr. Napoli for collating this information?
For properties or for these IAs?
No,
yes, both.
Only one. Their IA, we will have to respond as to they should be permitted to enter into that transaction.
After Diwali vacation. After Diwali vacation, about 2 weeks thereafter.
4 weeks from today.
4 weeks from today.
All the claims.
Lordships may clarify that even those purchasers whose IAs have not been listed be permitted to approach the learned amicus. Lordships. Lordships. Lordships may clarify that even those purchasers whose IAs have not yet been listed.
The parties who have very claims.
Small clarification, lawyer, that even companies can be sold by Sahara, Your Worship. That
If the properties are included in 88, you are concerned. If the properties are not in that 88, then you are not concerned.
Lords, for the employees, I have just.
only, my lord, implies IA may be disposed, my lord. It's a very small issue, my lord.
Properties, my lords.
All of you can give your details to the learned.
So am I cursed?
As the one of the CA has already dictated, he will identify this property.
Your Lordship's earlier on September covers that interest as well. There's a clarification already.
Dispute, serious dispute regarding title or where there is some cloud.
Then reported, Your Worship. There may be reported in the order because implies I. Company, Your Worship. It's not the main two companies, Your Worship.
The properties of all companies are directly be sold.
But it implies payment has to be cleared from Sahara SEBI account, my lord.
That 11th November suit you. 11th November.
That's fine.
My lords, some of the crystallized properties are in sealed cover. They have to be given access to the learned amicus to know, so that we can represent.
So if you have any claim, you lodge the claim with him. Then
Based on your lordship's direction, negotiated, settled, advance paid, and that MOU was placed before your lordships in a sealed cover.
That is not, that is a Coimbatore property, my lord. That is not part of this.
We are agreeable to that. We are agreeable to that.
So you will have to say that.
I said that twice over.
Once more.
I mean, you can't keep on repeating the same thing. He says, no, I didn't say it, I said it.
As regards to the Coimbatore property, the matter is not settled. A large number of home buyers.
22 out of 511.
EP is filed, so documents are attached. So behind the back, the settlement is.
22 out of 511.
You have not filed.
All IAs be listed, not all IAs in this matter be listed.
My lord, SEBI doesn't have objection. I just spoke to Mr. Venugopal. He doesn't have any objection.
There is an order of your
from
lordship.
Sahara SEBI account.
No, my lord. That order of 4th September 2024 says they have to file affidavits that has not been complied with.
We will file it.
Yes, they are not. No, we have not got any affidavits. They have to file the affidavit showing that the claim belongs to a group company whose assets have been sold. Unless that affidavit is that order is complied with, there is no question, my lord. Because, and secondly, my lord, Saharas have to disclose whether they are employees or not. Now, many people are claiming.
That is what we have said, that
yes, my lord.
Sahara should respond to the.
Exactly, my lord.
That's right.
Lordship, please.
Lords, I want to give their response to the amicus who may verify with regard to the employees also, Lords, because.
That is what we have already
Said
said.
already. Why? How many times will you say this?
Chorus, you don't listen to what we dictate.
I don't know what's
So instead of 11, can I have it on 17?
Not all IAs be listed.
On 11, there is some difficulty. Can I have it on 17?
Yes.
All IAs be listed. IAs be listed.
All. The application. You lodge the claims with them. It's not necessary that the IA should be listed. That's right. Without the IA being listed, we can also consider whether there are any claims on the parties.
Yes. Would your lordship be reassembling, bro? Would your lordship be reassembling, bro, for the main nature? Today, bro?
That part of matter.
No, I'm just asking, bro.
Yes. The other combination will sit for a partner matter, Mr. Sibal and
Oh, that's
right. Mr. Ravi.
Parthat. No other matter will be taken.
Except one, I think, for directions that is.
Please.
32, I think.
Please.
Lordship.
Grateful.
May I only mention, my lords, item 22 listed in the morning, my lords. Here the husband had flown the Indian jurisdiction, my lords, taken the child, punished for contempt. Only one IA for 142 divorce was pending. He's got a divorce in Kenya. This is that Ferry Kansagra, madam. Lords. If that IA could be taken up, notice was issued in 23. The man has not, he's not appeared since 21 minutes. If that IA could be kept, my lords, immediately after Diwali. Obliged.
Item 6, Your Lordship, testing the virus of the UP Gangster Act, Your Lordship. Matter has been listed twice in the past. Today it was also listed, Your Lordship. Could not be taken up because of the board's discharge. May indicated date, Your Lordship.
Item 18 that listed only for an application for early hearing. Mentioning has already been permitted twice. After mentioning only the early hearing application has been listed, which I had filed as far back as in March. I know this is a matter pertaining to the encounter killings in the state of certification. I'm only seeking that a fixed date may be given because it's not showing on the regular list since January 1st.
My lords, item 34, my lords, Your Lordship sir allowed the mentioning for the matter to be lifted today. Parties had settled it, my lords, way back in July before the mediation center. It's coming up for the joint application for dissolution. Friday, my lord. So grateful, my lord.
Your Lordship,
at 26 बाईस जुलाई को हमारा हुआ था नोटिस हुआ था 22 of July को कई बार बोर्ड पे आ चुका था अभी भी मेंशनिंग करते हैं आज लगाने का कल के लिए लगा this is contempt with land acquisition.
There is an MA in contempt.
Yes, what is the matter about?
Asking for compensation. He has got one the reference to compensation. He is filed the Lord, argument will be done by my council. Council has been appointed by this.
Diwali के बाद rate.
कल ये मिला
Diwali के बाद rate.
Your Lordship, I filed an intervention application, item number 6, my lord, related with the Gangster Act, my lord, and the police is threatening and raiding my houses, my lord.
Yes.
My lord, I'm slightly digressing from my submissions. Facts I will take it because there's another important submission that I'm making, my lord, is this. They want reading down of a provision of a central stat. They want reading down of a central stat, provision of a central statute to section 2S. That is the alternative prayer, my lord speaker. First prayer, which was the amended prayer. Now that prayer cannot be granted unless the union is made a party, my lords. Kindly have a look at one judgment of this honorable court. That is 2023 8 SCC 745. Union is not a party in these matters. It's a provision. Para 2. My para 8 of this judgment first, page number 37.
Read down, frame the
Page 37, para 8. Rerun A. My lord, the Chief Justice. But just the sentence starts one line above the dotted line. Another question which is required to be considered. My lord, so what is last line of page?
Yes, another issue which is required.
Yes. Well, yes, in the short issue before the bench is whether the judgments in Ranif and Arubian have been correctly decided whether active membership is required to be proven over and above the membership of banned organizations and the UAPA. Another issue which is required to be considered by this bench is whether American decisions concerning freedom of speech referred to in Ranif
to which this court agreed could have been relied upon while considering the right of freedom of speech available under the Constitution of India, more particular Article 19(1)(c), 19(4) of the Constitution of India. Now, this is important. Another question which is required to be considered is whether the court was justified in reading down a provision, section so-and-so of the UAP Act, without impleading Union of India as a party, and more particularly when the constitutional validity of all the provision was not called into question. Then, my lords, may kindly have a look at para 25.4. 25.4 at page number 49.
Yes.
On the submission made on behalf of the Union of India that without hearing the Union of India, this court ought not to have and or could not have read down section so-and-so of the UAP Act or section so-and-so of the TADA, the Sanjay Parikh learned senior counsel has relied upon decision of this court in Sanjeev Co. versus Bharat Coking Coal Limited. It is submitted that in the said decision it is observed and held by this court that no one may speak of a parliament and parliament is never before the court. It's further observed that after parliament has said what it intended to say, only the court may say what parliament meant to say, none else. It is further observed that once the statute leaves Parliament House, the court is the only authentic voice which may echo Parliament, and the court will do the same in reference to the language of the statute. It is submitted that while reading down section 10(a)(1) of the UFA Act and section 3(5), the court has interpreted the statutory provisions in light of 14, 19, 21 of the Constitution. It submitted judgments in reference correctly hold that mere membership of the banned organization will not make a person criminal unless. Then kindly have a look at para 59. Now, so far as section 10(a)(1) of the UAPA 1967 by this court in Arup Yuan is concerned, at the outset it is required to be noted that such reading down of the provision of a statute could not have been made without hearing the Union of India and or without giving any opportunity to the Union of India. Today, the Union of India is not before my lords. 60 also. Para 60, my lords. When any provision of parliamentary legislation is read down in the absence of the Union of India, it is likely to cause enormous harm to the interests of the state. If the opportunity would have been given to the Union of India to put forward its case on the provisions of section 10(a)(1) of the UAPA 1960, the Union of India would have made submissions in favor of so-and-so, including the object and purpose of enactment and such provisions, even the object and purpose of UAPA. Submission made by Sri Parikh, learned senior counsel, relying upon the decision of this court in Sanjeev Court that it is ultimately for the court to interpret and read down the provisions to save any provision from declaring an unconstitutional is concerned. It is true, it is ultimately for the court to interpret the law and or particular statute. However, the question is not the power of the court, the question is whether it can be done without hearing the Union of India. Therefore, Union of India is not a party, they may implate or my lords may direct Union of India. Then my lords may kindly have a look at the next page. Second paragraph, just above para 63. At the cost of reputation, it is observed that reading down a particular statute, even to save it from unconstitutionality, is not permissible unless and until the constitutional validity of such provision is under challenge and opportunity is given to the Union of India to defend a particular parliamentary statute.
Be a prayer.
Without
it can't be, Maharaj. So many times under section 45, Maharaj, of the PMLA itself, it was read down. It is not that the Union of India had to be mere party. Income Tax Act, Maharaj, you read down several provisions. Union of India is not
the party. I'm sorry.
You challenge the constitutionality in a given circumstance. The court may feel that to uphold the constitutionality, you read down the provision and ensure that it is there.
That's correct.
But then, can you make a prayer for reading down as such? Is that
correct, Maharaj? You can otherwise read it down, Maharaj, even if you don't make a prayer.
That is only if there is a challenge on the constitution.
Maharaj,
that's going to be my second submission. Electronic corporations.
Let's assume, Maharaj, that you don't grant me that prayer. My basic objection is, Maharaj, that they are investigating the matter which is a predicate offence. Corruption will be investigated by the state, not by ED. They say that there are individuals who are corrupt, Maharaj. Otherwise, if we give consent, CBI will investigate corruption. Otherwise, the state will investigate. Who is the ED to investigate corruption? Who is the ED to investigate corruption, Manoj?
I am not
We are
investigating
chatting
corruption.
there, right,
My statement
Manoj?
may be, I am not investigating corruption. I am only investigating money laundering.
That's
I am
not
not
case.
investigating corruption.
There's their case, Manoj, in the counter. These
It's
people
only
are
a
just see their paragraph.
Wild allegation made. I am not investigating corruption.
counter
I am
of-
making a statement with all seriousness.
No, 1 second. But if I now that I'll answer that, kindly come to page 2 of their prayer. Page 2, para 5. Regional managers, taskmaker indulging in collection of bribes for transfer of posting. What has that got to do with ED, Manoj?
That
Or
only
Manoj, it is
description of the
alleged
predicate
that
offence.
officers at level of district managers and senior managers are indulging in high-level corruption. What has that got to do with ED, Manoj? Just see that FIR has been registered on the issue of representatives of breweries approaching taskmaker to take off high take. What has that got to do with ED, Manoj?
It's only a
Everything
description of
that
the
they are
predicate
saying in their
offence.
counter relates, Manoj, and they have investigated none of them. They have only investigated the corporate office. Manoj, they have not gone to any regional manager. They have not gone to any district authority. They have not gone to the breweries. They have not gone for transfer. Nothing. They are only rated the corporate office.
They
And,
fully
Manoj,
operating.
and
They're fully
FIRs were
operating.
being registered from 2017. May I just tell your lordships? This is very telling. Since they have been investigating, we have been lodging FIRs in 2017. How have they rated in 2025? Many of these FIRs have been closed prior to
Such
in
is to the reason
2021,
bottom class
2022.
is not correct.
They are.
Are you pressing for this prayer?
No, we need not, Manoj.
No, now.
No, I will not press for it.
You say that we will record the.
Yes, your lordship may record it. Let him justify, Manoj, on what basis he is proceeding.
We are against.
Yes, he is not pressing for that.
Very well, Manoj. I am obliged.
Though I have some problem with the
He
proposition.
gave up
I'll
the
leave
prayer
it,
in
Manoj.
federalism in the High Court. Now he's given up even the. Very well, Manoj. And now kindly have a look at the other prayers.
Actually, in the course of prayer
163, my lords. My lord, ordinarily the courts do not interfere in investigation. Your lordships have held that investigation is the domain of the investigating officer. How and where and when to investigate is the domain of the investigating officer. It is settled by a series of judgments. Sole prerogative of the investigating agency may have 12 judgments on this point, my lord. So whether I have to search place A, B, I don't have to take anybody's advice. Even the courts should not interfere in such matters. But I have a compilation of judgments, my lord. Can you give the hand on additional judgments? Kindly have a look at JSS Saldana, my lord, which starts at page 238. Relevant paras are 19, 25, and 27. Page 261, my lords may have a look at para 25, my lords. There is, my lords have got page 261, para 25. There's a clear-cut and well-demarcated sphere of activity. I'm sorry. 261, running page 261.
Yes.
Para 25. There's a clear-cut and well-demarcated sphere of activity in the field of crime detection and crime punishment. Investigation of offence is the field exclusively reserved for the executive through the police department, the superintendents over which vests in the state government. The executive, which is charged with the duty to keep vigilance over law and order situation, is obliged to prevent crime, and if an offence is alleged to have been committed, it is the bounden duty to investigate into the offence and bring the offender to book. Once it investigates and finds the offence having been committed, it is the duty to collect evidence for the purpose of proving the offence. Once this is completed and the investigation officer submits his report to the court, requesting the court to take cognizance of the offence under section 190 of the code, its duty comes to an end. On the cognizance of the offence being taken by the court, the police function of investigation comes to an end, subject to the provisions contained in 173(8). That is further investigation. There commences the adjudicatory function of the judiciary to determine whether an offence has been committed, and if so, whether by the person or persons charged with the crime by the police on its report to the court, and to award adequate punishment according to the law for the offence proved to the satisfactory extent. Thus, there is a well-defined and well-demarcated function in the field of crime detection and its subsequent adjudication between the police and the magistrate. This has been recognized way back in King Emperor versus Khwaja Nazir Ahmad, where the Privy Council observed, as under in India, as has been shown, there is a statutory right on the part of the police to investigate the circumstances of an alleged cognizant crime without requiring any authority from judicial authorities, and it would, as the Lordship think, be an unfortunate result if it should be held possible to interfere with those statutory rights by an exercise of inherent jurisdiction of the court. The functions of the judicial and police are complementary, not overlapping. Therefore, ultimately, a series of judgments have taken the view that investigation is the exclusive domain of the police authorities. If that is so, unless there is totally arbitrary action, totally unconstitutional action, the court should not interfere and should not direct that you search this place, search that place, do something in the investigation. Now, as far as the other judgments, I need not refer, but they're going the same line, so I need not refer to the other judgments. Now look at the other prayers. Now kindly come back to page 163. If the constitutional aspect and reading down is left out, what are the prayers? It essentially tantamounts to interference with investigation. And also consequential prayers. There are some in the other petition. Now kindly have a look at page 163. Of the SLP. So if you ignore the first prayer,
taken by you?
By us? But we have registered an ES by the state or by us?
By you.
We have registered an ECIR and we have searched this. We have not arrested anybody, nothing. And thereafter there's a stay.
No, but after ECIR, have you taken any steps on the basis of that ECIR?
We have recorded some steps. We have searched this premises and recorded statement. That's all. Nothing else has been done. We have searched distillers. We have searched the TASMAC office.
Have you proceeded against any of the accused?
No, we have not arrested any of the accused. Nobody is arrested. Nothing has been done. Before we unearth and get evidence, this petition has been filed so that the evidence disappears and we don't do anything and huge corruption is swept under the carpet. ECIR, where's the ECIR? ECIR. I've asked my officer to remove it. It's not there, but I've asked my officer to remove it. We got a copy. You got another copy? Yes, we got It's an internal document. ECR is an internal. Vijay Madanlal has said not akin to an FIR, not statutorily required to be registered.
This is correct. This is not correct. It's sovereignty of the nation. I will say it. There's also reason to believe this question with the High Court has said this is not completely. And also, you can say that that's a review provinces can be. I think this is very difficult to speak with it. Was to be placed to meeting. No, I know, but I mean, don't know what that is. But not is not even that. We come to first the assembly expired in 2016. They have rated it from the election after 4 months. Yeah. That's it. I mean, it's it's all fixed, actually.
Why this? We have not gone again. We have just got recorded a statement and got
against Mr. Senthil Balaji.
That's a different case. Cash for jobs scam. The transport department. In the transport department, that's a different case. This court has granted him bail. This court has granted him bail. He's not arrested in this case. But we have got material which shows, my lord. Therefore, my lords may kindly have a look.
So because most of the allegations are against him in this
material that has been got is the allegations, material which has been obtained is he is confronted, he is denied, it's not material we have gathered. And we have found that
this is akin to an FIR, is it not?
No, it's not akin. Vijay Madan Lal says it's not akin to an FIR. FIR is statutorily required to be registered. It's only an for internal purpose.
This you will proceed with the investigation and register the FIR.
No, we register a prosecution complaint. We lodge a prosecution complaint. We are not a moment we register a charge sheet, we become police officer. We are not police officers, therefore we file a prosecution complaint.
ED doesn't supply ECIR copies to the
there are authorities that that issue is pending.
Safeguard of an FIR. Under a lordship judgment, an FIR has
Vijay Madan Lal is clear.
The net within 24 hours, so people can read it and go and apply for bail. ECIR is registered in their office. Nobody knows. Somebody can go and pick up somebody and say, well, we have an ECIR. That man has no idea. This is the procedure.
They don't tell him they can record a
channel was there in Vijay Madan Lal.
And that now subject to review before
they have raised up this issue again.
Therefore,
it is very challenged. ECR is not an issue. With the copy of the ECR is not an issue in this matter. But they have not asked for it. They have not asked for it, but Vijay Madan Lal categorically says there is no statutory requirement to register.
It's under
we may start investigating without an ECIR also. There is no requirement in law that we should register an ECIR. But administratively we are doing it.
High Court directed them to supply, they didn't give, but that's Vijay Madanlal Chaudhary. That's why you didn't give.
Vijay Madanlal Chaudhary says,
And that's
but
under
now
review
I have,
now.
my lord, now I have advised the ED that you just record an ECR saying that these are the FIRs, give them a copy.
Good. You should do that. At least we know what's against us.
You can give them a copy.
Even
But why should this document not be supplied to us? It's about Senthil Balaji. Why should it not be supplied?
At least in that case.
Yes.
Why the
Volume 3, 4, 5, 6, 4, 5, 7 is here. ECR may not be shared.
Other side, but can the court peruse it?
Of course, court can peruse it.
Something like a case diary.
It's not the case diary, is the file. Because the court can always peruse it. There is no impediment.
Under CRPC,
172C.
the courts can refer to a case diary, but an accused is not entitled to have a look at it.
Yes. Nothing, my lord, we are not shy of giving anything to the court. But our investigation is at a threshold. It will jeopardize an investigation if material is given to them. They will know, they will ask for retraction of statement. So many things will follow. Not at this stage. And the issue is wide open before the review bench of Vijay Madanlal, where they said ECR copy has to be, though Vijay Madanlal says, no, it's not a statutory document. There is no requirement in law to register an ECIR. I can start investigating without an ECIR.
Why not do it?
Vijay Madanlal, may I hand over the copy of Vijay Madanlal, which category deals with this point, my lord?
No, that's conceded. That Vijay Madanlal, that's under review. You know that. There's an order of the court. Let's talk about the facts as to what you're doing with Senthil Balaji. Tell us that's your objective.
And that's not my objective.
If this is what the ECR says, Senthil Balaji, that's your objective.
Our
You are protected. No, just here, sir. You are protected. Now that other judgment is under review.
Yes.
See, if at all we do something here, we will be bound by the 3-judge bench. It's a 3-judge bench.
Yes, 3-judge.
Still, until it is reviewed, it cannot be possible for us to say anything against that.
Whereas I'm not on ECIR. At the moment, I'm not.
No. We know you are not on the ECIR, but then on a consideration, we'll have to look at it in a comprehensive manner.
But he is saying that your lordship may look at it.
Other judgment stares at us, which is also under review. Why not we adjourn it and hear it after some time? Let the review first be decided on that.
Well,
Probably this could also go to
the problem is the following, Malas. I just want to give me 2 minutes. Problem is the following. Their submission is that every time there is an FIR lodged anywhere in the country, ECIR can be lodged by the directorate. That's the law. Because that's what Vijay Madanlal Chaudhary says. Because once there's a predicate offense.
So that is why we are saying that when that is under review, why should...
No, that's not under review, Malas. That's not under. That's the issue.
Vijay Madanlal Chaudhary.
On the ECIR is under review, not what I'm telling your lordships. Malas, their proposition.
There, my learned things are different.
Will your lordships give me 2 minutes? Malas, just kindly come to section 3 for a minute of the PMLA. This is the real problem is this. And we've been waiting for years.
We just now read section 3. We read section 3.
Of PMLA.
Now you started asking you this question.
Of
We read
PMLA.
section 3.
Of PMLA.
Yes, PMLA. That
Yes, now Manas, that and or has been converted to or.
That is approved by Vijay Madanlal.
Just have a look at that for a minute. This is the real problem in the case. Which is why they run.
Vijay Madanlal dealt with this issue extensively.
Will you allow
and or
allow me? I'm just
every time he argues Vijay Madanlal. I'm sorry.
Yeah, every time you argue the same thing, no? No, whosoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with proceeds of crime, including its concealment, possession, acquisition or use, and projecting or claiming it as untainted property shall be guilty of the offence of money laundering. So, Maharaj, whoever is doing this and projecting it as untainted property.
You can't argue contrary.
I am not arguing, I'm just explaining something.
To the submission there.
Maharaj, just will you allow?
Very well. And that's
This-
not even an issue here. I'm sorry.
Now, Maharaj, what happens, then an explanation comes. And this explanation is in Finance Act 2019. What does that explanation say? For the remover of doubts, it is hereby clarified. A person shall be guilty of the offence of money laundering if such a person is found to have directly or indirectly attempted to indulge or knowingly assisted or knowingly is a party or is actually involved in one or more of the following processes or activities connected with proceeds of crime, namely concealment, possession, acquisition, use, projecting it as untainted property. So the explanation changes and to or, upheld by Madan Lal Chaudhary. So, Maharaj, there is no difference between proceeds of crime and projecting it as untainted property. Result is that every time there's an FIR lodged anywhere in the country, ED goes in. ED goes in and says there's an FIR, predicate offence is there. I don't have to go into and projecting it.
Because of Madanlal Chaudhary.
That's the explanation. Yes, you're right. You're right. Now, Maharaj, the question is, it's a corruption. Corruption involves individuals. How do they raid a corporate office for corruption? My objection is,
Now, see, you are not holding cudgels for all the FIRs which could be registered. You are concerned with your case.
that's right.
Let it come after Vijay Madanlal's review is all we are saying. Why? You are protected fully.
Yeah, but therefore, I want this all proceedings square the corporation because it's a government corporation. It has nothing to do with individuals.
You are protected. You are protected completely.
Then we also may grant rule, Maharaj. Grant rule and let it come up. Grant rule and let it come up.
Leave granted. For hearing parties, the chief order, self-stand confirm.
Let it come up after the review.
Yeah, appeal to come up after the review. It's Vijay Madanlal Chaudhary. Decided.
Yes. And then there are those privacy matters, Maharaj. Those all may come up together, Maharaj.
Which matter?
Those
That's a
privacy
different
matters
matter.
of mobile phones, that also is
How can
involved
a
here.
corporation talk of
Future
privacy?
gaming,
No
that
individual is before my lords.
Read petition 515 of
Because Swami says corporation not entitled to privacy law.
This being tagged
Fundamental
as
rights
petition
not there.
515 of 2024 also, Maharaj, because the same issue will be involved there.
My lord,
that involves
observe that
mobile
he's
phones.
given up the prayer, my lord. He has given up that reading down prayer, my lords may observe, my lords.
No, that's all right. That I
That
don't
may be
mind.
observed
Give
because
up.
that is what is said.
But once it is rule is being given, Maharaj,
No,
you can argue that.
he has given up that prayer.
Maharaj, my
Not
request
fairness,
is
my learned friend should accept this.
tag it with grid petition 515 because it also involves seizing of mobile phones.
No, it need not be tagged.
302, Maharaj, in our SLP. 302.
At least his statement may be required. He made a solemn statement before this court.
Mobile phone seized in this case is the instrument.
After Vijay, we don't know when it will be reviewed because for last 3 years I've been hearing that it is being reviewed, it is being reviewed.
Maharaj, we've been trying very hard, Maharaj, but somehow. So,
Last
Maharaj,
time, Leonard Friend-
515. Tag it with 515. Kar diya, deeply obliged.
Now, in case there's no seizure.
And once, Maharaj, the elections take place, then there'll be no interest, Maharaj, because this all happened in 2015.
Sorry, no.
25, Maharaj, 2025. 26th is the election in 26 early, Maharaj.
No, this is not incorrect.
Election is 26 early, Maharaj. So this all happened in 2025.
What Mr. Sibal
Let's take the better.
Why are Leonard Friend politicizing the issue, my lords?
This all is.
For one.
I don't want to say anything, but I have said it here on the last day.
What my lord said in the morning is already reported. May I show that? What my lord.
I have not said anything.
No, that is all reported.
The fact that he won't say
Very unfortunate.
That my lords will not say anything is also reported.
Which is good. Because in that statement, there is a lot already said.
So Dharmadhikari must be aware about many things.
No, I was not correct.
My humble request, that statement of his that he is not present there.
Let it clear. It can't be granted, it can't be granted. Now, the outcome of this proceedings will depend on Vijay.
Made a statement. I'm only asking what he has said. I'm not asking.
I don't know what's the point of all this. You will succeed anyway. But he'll succeed. He'll raise the same issue. He'll succeed, Maharaj. I've got a lot to say on that. Therefore, don't make any statement. We can amend the prayer, we can do many things. Yes. Why should
We can
we had attacked the statute, we can amend it. We have plead the union.
We never not said it in the beginning, I want to amend.
And
Give us a chance.
What is the problem?
I'm sorry.
We will implead Union of India as a party.
We can implead Union of India. What's your problem? We'll challenge the statute.
We will leave, you grant them leave to implement Union of India.
My lord, we grant this.
Deeply obliged. It's tagged with 515.
Yes, you have passed it out.
Yes, keep it.
The Lordship not allowed him mentioning in the morning, Maharashtra State Electricity and
Day after tomorrow. After we mentioned Miller, we have received an email at 11:30 this morning after the mentioning, granting us time till 10 a.m. tomorrow. If in the failure of producing an order or injunction or anything, they would impose regulations tomorrow by 5 p.m. We have received that email.
They will what?
Impose the regulations under the late surcharge payment regime by tomorrow 5 p.m.
Serial number 1
Lordships may have it tomorrow.
Tomorrow I have more.
Grateful.
But Mr. You have breached the rule.
I was not mentioning.
Yes, sir.
This was very extraordinary.
No, but then we are no extraordinary.
Anyway, you should ignore mine. I was here, so he caught me. I have not mentioned after that day.
Yes.
She made the rule, I have not mentioned. This was very extraordinary for me.
Grateful.
Please, my lord, on 7th of October, your
Let me say one thing. Provident Fund.
Yes, my lord.
Provident Fund is not, the priority does not relate to Provident Fund. Let's see 26E. 26E of the SARFAESI Act. It says of notwithstanding anything contained in any other law for the time being in force after the registration of security interest, the debts due to any secured creditor shall be paid in priority over all other debts and all revenues, taxes, cesses and other rates payable to the central government or state government or local authority. So it is only the taxes, cesses and duties and dues to the central government, state government or local authority. The PF Act has a first charge. So PF definitely has to be.
The provision itself creates the statutory charge. And one more thing, Lord, these dues are.
And even when you see that the judgment you pointed out in Union Bank or
MSC Bank versus the
even in that case, if you look at it, the Central Excise Act at that point of time did not have this first preference.
Yes, my lord, but
that is why they said that look at section 35 of the SARFAESI Act.
Yes, notwithstanding.
Section 35 is not to get over priority of charges. No. Section 26E gives priority of charges only as against government dues. So then what happens is PF, you will have to give it to them. PF. Then again, workmen, unfortunately, we don't have a first charge for workmen. Workmen's dues.
There is an earlier High Court order which has.
No, forget the work. See, if it was under the IBC, the workmen have a priority of charge. And even in the company's law earlier, winding up, they had a charge. But here there is a liquidator appointed under the Cooperative Societies Act, probably. That if that doesn't provide for a what do you call preference to, does it provide? Does it? The Maharashtra Cooperative Societies Act, does it provide a preference for workmen or for liquidation?
No such provision. Only thing is, there are some judgments of your lordships where they say the workers' dues and the secure credit pari passu, that's the
Cannot be, but
529.
By this provision that is taken over.
Only here one more thing. Securitization Act came into force on 2002. The workers' dues are ranging from for the period commencing 1989.
But then, first of all, there is no first charge. And here is a case when 2002 it came. If the PF Act, if it did not have a first charge, probably then the priority would have to be given to them. Now there is first charge.
There is one High Court order, which will be directing the worker to go to the liquidator. And liquidator is directed to make the payment that has attained finality. the order passed by the industrial tribunal was challenged before the High Court. And that High Court's direction, that is 2015 order.
Milord,
They are-
I will explain.
You lost before the industrial court.
That is what.
You lost before the industrial court.
Yes.
Yes.
Delay was dismissed. See, your challenge.
Yes,
No, your challenge, what happened was, please, the single judge only said that, considering the fact that a liquidator was appointed, let the liquidator decide.
Industrial court will have dismissed our complaints on the ground that there is delay application.
3 grounds.
Thereafter, when writ petitions were filed before the High Court, that order is of
That is what I told you.
Yes.
What did the order say? The liquidator will decide.
Yes, there is one option, either go before the tribunal or to the liquidator.
You took the option of liquidator.
Liquidator. This was the direction. There is an order that directing the liquidator to make the payment.
The liquidator may probably compute the dues, but that is not, liquidator does not have the power to keep it with him.
And that is subject to Supreme Court order 1. Secondly, my lord, 2001, my lord, the liquidator was appointed in view of section 109, only 6 years tenure for completion of proceedings.
The Cooperative Society.
Cooperative Societies Act, section 109. At a stretch first 6 years, at a stretch 6 years, thereafter 1 year separately up to 10 years, and after 10 years, even take his case from 201 or 202, 10 years over by 2012, then special permission from government required for a period of 5 years. That is also not there, and after 15 years termination, 15 years completion, deemed termination of winding up proceeding.
Why did you not point out that full bench decision of the Bombay High Court, which dealt with this?
Which one, my lord?
You're both from Bombay. Full bench decision where the Chief Justice, Justice Deepankar Datta, had considered this 26C. Elaborate judgment.
I am sorry.
They did not tell you because it is the judgment of the High Court.
One more thing. Employees.
But one issue I have a doubt whether the sufficiency proceedings are.
And my lord, that page?
Page 380 is the one that
Very
the
big.
PS.
My lord, even PF dues are paid is a different, on merit I am saying at page 380, PF dues are paid, that is one. Secondly, so far as the 2001, 2009, 1 SCC page 123, my lord, that time 26E was not available, that is the point.
But PF dues you have to pay.
Yes, my lord.
We have already paid.
May I make a separate statement? So far as the PF dues, my lord. My lord, no fault of workers, my lord.
We are going to allow it.
No, one more. My lord, EF, my lord, is deducted from the salary of the employee, my lord. Now, my lord, this from 80, period is 1989, my lord. My lord, I'm praying that, my lord, it may be paid, my lord, with interest, my lord.
That definitely the provision provides for that.
That we are grateful to you.
I am